pretrial conference, the complaining witness is present, the court is going to continue not guilty pleas on behalf of each defendant, set the matters for trial. With respect to the trial, for Mr. Bracy, Mr. Bracy, by her words, your lawyer has indicated that you want to waive your right to a jury trial and have the case heard by the court, meaning me. Is that what you want to do, sir?
Yes.
And Mr. Bracy, do you understand that if I accept this waiver today, that while Ms. Lynise would have a sitting in the jury box, your case would be decided by me? Do you understand that?
Yes.
Sir, has anyone threatened you in any way or promised you anything that was not placed on the record to get you to waive your right to a jury and have the case heard by me?
No.
Any objection from the people?
No objection, Your Honor.
Having no objection from the people, finding that the waiver has been made freely, knowingly, and voluntarily, the court accepts the waiver. So with respect to Mr. Bracy, the court accepts the waiver. I'm gonna set the matters for trial. Have people submitted discovery yet?
Yes, for both of them.
Okay. I'm gonna set the matter for trial August the 6th. With a final pretrial conference July the July the 2nd. All right, and that's of course at 10:30 for the jury trial, the final pretrial conference. Is at 9:10. If there are any issues that the court needs to address with respect to the jury trial or the waiver trial, but if there are any issues, any motions, those things need to be filed so that they can be heard by July the 2nd. Anything further with respect to the matters?
No, thank you, Your Honor.
No. Nothing on behalf of Mr. Bracy. Thank you, Your Honor.
All right, Mr. Hernandez Morales, with respect to the July 2nd date, sir, you're not required to attend that court date. You may attend if you want to, but you're not required to attend. However, of course, you are required for the August jury trial date. So make sure you don't make any plans, if you intend to testify for the people on August the sixth.
I
Okay?
understand.
All
Yes, I
right, then
understand.
we're all set. Everyone have a great day and stay safe.
Thank you.
All right, Ms. Robinson, are you ready on your next case?
Yes, Judge.
All right, let me get, oh, I'm sorry, I asked you, were you ready, but I don't see your client. Hold on, let me try to identify some of these unidentified individuals first.
Yes, Judge.
All right. Okay, who's unidentified? Let's see. Ms. Stevenson, I'm sorry, Ms. Ritter, did you need to speak with, Reed, Ms. Reed? Well, we're gonna bring her in, but you don't know. Ms. Stevenson, I thought I sent I thought I sent them to the breakout room.
You did. Mr. Mooney, can you help out with that one?
Yeah, he was struggling, so I asked him to leave court and try and rejoin, hoping that it would work out for him better. I'm not sure if it did.
All right, can the person on the One Nord plus device please unmute and state your name for the court?
Deanna Glover.
Thank you. Ms. Glover, I'm going to send you, oh, I guess I'm not. I mean, Ms. Stevenson, how do you know she's properly dressed? You just believe in your heart?
If she's okay with the court, we've already spoken
No,
with
I'm
her,
not
Your Honor.
gonna find out. Ms. Glover, go to the breakout room and then the lawyer will come in to see, to make sure it's in court.
Okay.
Ms. Easton, I thought I also sent Ms. Rampus to the breakout room. Okay. Can you tell me who's the person, because my chat is, I didn't mark it before I checked.
Roger Marshall. Then there's Gerald Mayweather. That was Johnson.
You want to send the person that said they, that's the only thing they can do, and send it to Salvation Army?
Ms. Stevenson said she was.
I'm ready on, oh, Ms. Robinson,
Yes, Judge.
your client, Mr. Saeed, is not here. You might need to try to reach him.
Okay, I talked to him last night. I'll give him a call.
Okay, well, to his, well, yeah, he is 15 minutes late. Yeah, I have no more unidentified devices, so, who? Oh, I'm not being honest, there he is. It's too many people in my waiting room, okay, Ms. Robinson.
Yes, Judge.
All right, then, let's go. Oh, no, I didn't mean to bring in Mr. Hermes yet, I didn't mean to bring him in. Okay, so, let me change the settings so you can start your camera. And then, Miss, I think that's a Miss Reed. Start your camera for me. I'm gonna send you to a breakout room so that you can speak with the prosecutor. Please accept to join the breakout room and wait for the prosecutor to come in to speak with you. Okay. Let's try to get Mr. Saeed's camera connected. All right, Mr. Saeed, remove your hat, please.
Yes, ma'am. Hello.
Mr. Saeed, I need you to stabilize your device. I need you to be stationary in an upright position and ready to attend court.
Yes, ma'am. Just give me 1 second to get prepared, please.
You should be prepared when you log into court. You're supposed to already be prepared. All right, Ms. Robinson, I'm ready. Come on screen.
Yes, Your Honor, I'm here.
Mr. Hayes, if you could just pop on screen for me. Thanks, Mr. Hayes. All right, I'm ready on Saeed. This is case number 204556301. The people of the state of Michigan versus Hashem Saeed. The defendant is charged with 1 count of malicious destruction of property. Today is the date set for final pretrial conference. Appearances, please.
Good morning, Your Honor. Caitlin Public on behalf of the people requesting permission to practice under Michigan Court Rule 8.120. I'm currently a 3rd-year law student in good standing at Wayne State University, and I'm being supervised today by Assistant Attorney General Robert Hayes.
Permission granted.
Good morning, Sarah Robinson, P63181 on behalf of Mr. Saeed. Sir, please state your name.
Hasham Nasri Sayed.
Thank you. Today's the date set for a final pretrial conference. Ms. Robinson, how are we proceeding?
Jury trial.
The court is going to continue a not guilty plea on behalf of Mr. Saeed, and I will set the matter for trial. The court will set a trial date of August the 20th, if that's a good day for you, Ms. Robinson.
May I check, Your Honor?
You may.
August the 20th looks fine.
All right, court sets the matter for August 20th at 10:30 a.m. with a final pretrial conference, August the 7th. Whoops. If there are any issues for trial, then you all need to file any motions so that they can be heard by August the 7th. All right, anything further?
No, that's all. Thank you.
Nothing from the people, Your Honor.
Okay, then you're all set. Have a great day. Stay safe.
Thank you.
You're welcome. All right, I'm gonna put you back in the waiting room. When Mr. What's his name? Colasa comes back. He should be back in a few minutes. Or you're free to log off, but I'm gonna put you in the waiting room, and then he said he should be on at 9:30. Okay. So, Ms. Stevenson, are you already on Ms. Rambis, or do I need to send her back to the breakout?
So I think she needs to go back to the breakout. I'm not sure whether yesterday we thought maybe Ms. Coleman would be on that case today.
Who was Ms. Coleman?
She was she was Ms. Rambus's attorney, and she's what Ms. Rambus told Mr. Byrd yesterday.
And where is she?
I'm
Oh,
sorry,
wow.
Your Honor.
Main room, can you call Ms. Coleman, Taylor Coleman? Okay. All right, please accept to join the breakout room and wait for the lawyers to come in to speak with you. Mr. Schweshwitz, I don't know how to pronounce the name, he still doesn't have sound. Ms. Gerard, please start your video. Please accept to join the breakout room and wait for the prosecutor to come in to speak with you.
On Mac, Judge.
On what?
Maria Mac.
Now tell me why all of a sudden did your thing appear up here? Okay, we don't know. All right. I'm ready on Marshall. Oh, that's the person that's in the hallway?
Yes.
Okay, I'm ready on Mayweather. Oh, no, I'm not ready on Mayweather. Mayweather is a sentence. Okay, I'm ready on, oh, both of those are sentences. Okay, give me a moment. I gotta get ready. All right, then I need two sheets too, I didn't break it down.
Okay.
I'm ready on, I guess I'm ready on Marshall. In the future, we're gonna send the people down to the Salvation Army. I'm not gonna do this right here. All right. Can your client hear us? Ms. Dixon, can you unmute, please?
I'm sorry about that. Yes, Your Honor.
This is case number 146193701. The people of the state of Michigan versus Roderick Jerome Marshall, defendant is charged with Is this my case? One kind of a security bill, that's no insurance, correct? Who was the previous judge director?
That's the problem. 2015.
Okay, one count of security bill, today is the day set for. A pretrial appearance, please.
For the record, Your Honor, this bill read on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Roger Marshall. Mr. Marshall, sir, please very loud say your full name.
Roger Jerome Marshall.
We can't hear him.
Roger Jerome Marshall.
We can't hear him, that's why I don't wanna do this. Just let them come on in the courtroom with the ripped up jeans on that's outside of the court's dress code policy. Let's just come in the courtroom. No, he gotta come back right here by his lawyer.
No.
All right, state your name, sir.
Roger Jerome Marshall.
Thank you. Today's the day set for a pretrial conference on the 2014 case that I don't even think should be mine. How we proceed?
Your Honor, on behalf of Mr. Marshall, we ask the matter be set for final pretrial conference. We are attempting to work the resolution out that'll encompass this ticket, this case.
It's a ticket. You said it right. It's supposed to be a ticket. It's not supposed to be here, but it's in a whole file folder. So that's probably why I think it's here. But it should be a ticket and it should be in one of the ticket courtrooms, but okay.
So he does have a matter pending before Judge Wagner on, February 7th. So.
That's Friday.
Yes,
So do we want to adjourn this till Friday?
until after Friday, or we can do it the same day, it's up to the court.
I mean, you said you're trying to work out a resolution that includes that. So do we want to do it on Friday?
I'm fine with that.
All right, then let's adjourn till Friday.
Okay.
Is his case with Judge Wagner in person or on Zoom?
It's not specified, but it's at 8:45.
Can you call and find out if he's supposed, well, they're not really doing in-person traffic.
It's pretty much on Zoom.
It's pretty much on Zoom. So is he gonna come on Zoom or in person? So you all need to know how to. I mean, it sounds like you need to talk to the prosecutor beforehand on Friday.
He'll be coming in person on Friday.
Okay, without those reviews.
Mr. Bunch.
Yes.
He was on his way to work.
I know, talk about them, the only pants he had. No, not the only pants he had.
No, these ain't the only ones. This is the only pants I had at the time.
Right, I know they wasn't telling the truth. I used to have pants that I would give out, but people probably took my stuff during COVID. I don't have any over there, but, all right, just no ribbon, okay? Even though I don't, it don't look like those are truly ribbed, it look like they're not the ribbed, so you can see the skin ribbed, but, okay. All right, let's adjourn till Friday, and then we try to get a resolution.
Thank you. Your Honor.
Thanks.
All right, you're welcome. What time is this hearing with Judge Wagner?
8:45, Your Honor.
Okay, so let's just put it on for 8:45.
Thank you, Your Honor.
Go to Wagner first. Go check in with Wagner. Is Wagner on this floor?
Yeah, all the way at the end.
Yeah, he's all the way at the end, so check in with them first, then come here, check in with Ms. Easton, so they can see what they worked out, okay? All right,
Thank you, Your Honor.
you're welcome. Okay. Mr. Sharp is here, that's the same. I guess I'm gonna just have to take a recess and get ready for my No, wait, hold on, this is, oh, Colossus. Hey, it's 30 minutes. And then you said, Mr. McCree said he was on Magna, but Rand there is in the,
Representing a party in that case.
oh. Good morning and welcome to 36th District Court. When prompted to do so, please unmute and tell the court your name. Can the TCL T767 unmute and state your name?
Michael James Clay.
All right, Mr. Clay, you're an hour late.
I'm an hour late?
Oh, yes, sir, you're an hour late. You know you're an hour late. I'm gonna send you
No,
to the break.
I'm sorry, man. My paper
I'm gonna
says 9 o'clock. My paper says 9:30.
I'm gonna send you to the breakout room.
Okay, ma'am.
Okay.
Okay.
Can the individual identified as the only unmute and state your name?
Delisha Grant.
I'm sorry, ma'am, what's your name?
Delisha Grant.
Is this your witness, Mr. Renner? Was that Delisha Grant? Oh, I guess so. It's investigation grant who needs to be getting a silent place.
That's the only judge, or is it the iPhone? I'm sorry, I looked away.
You may have to look away. You were supposed to be hearing me say the person identified as the owner. I need y'all to pay attention today. It's a heavy day today. Can the person on the iPhone please unmute and state your name for the court?
Good morning, Your Honor. My name is Edward Kellis.
Thank you. Mr. Kelly, you're a little late too, but just hold tight. Your lawyer is here. I'll be with you short.
Yes, ma'am.
Okay, I'm gonna do cases in these. There. You're all. Did you reach Miss? Okay,
No, let me call her back.
Miss Stevenson, don't you? Oh, Miss Stevenson left. Don't you work for them? Ms. Barrett, good morning.
Good
Oh, let me
morning.
check.
How you doing?
I'm sorry. I'm well, thank you. You can start your video. Ms.
Okay.
Barrett.
Hold on one second.
Mhm.
Okay, there it is.
Okay, Ms. Barrett, you were appointed to represent, Ms. Urell, correct?
That's right, Judge. This is Judge, correct?
Yes, oh, yeah, y'all can't see me. I'm up
Well,
here.
yeah, I can't.
Let me zoom in on myself. Hold up.
I was recognizing your voice though.
Mhm.
Oh, there you are.
She hasn't, she was supposed to come in person. She hasn't appeared in person nor on Zoom yet. And I have a feeling that she may not come, but, if you could put your phone number in the chat, Mr. Flanagan can call you if she shows up.
Oh, you know, Judge, I did speak to her. I'm surprised that she's not here.
You spoke to her?
Yes, Judge. I spoke to her yesterday.
Did you?
Yeah, so that's why I'm very surprised. I can try and call
She
her
said she was
again.
coming in person?
That's what she indicated. And so
Oh,
that's
maybe running late. Okay, listen, she might just be running late. So, you can,
you want me to
Officer
put
Grant, is
my
anyone
number in
home?
the chat?
Yeah, put your number in the chat. And then maybe
Okay.
you can call her back again and ask her, is she on her way?
Okay, I will.
We'll call you when she gets here, but maybe you can.
I put my number in there and I'm gonna see if I can find out what's going on. Is there a number I can call at the court?
Yes, 965.
2295.
2295.
To what?
2295.
Okay, let me see if I can find out what's going on.
Okay, all right.
All right, thank you.
Okay, good morning, council. All right. That's everybody, so, yeah, just hold on. So, Mr. Kalasa, I see you've made it into the office.
Yes, thank you.
Welcome. So I am gonna go ahead and I'll handle that case, first, and then Mr. Mr. Ramsey, you're on Mangum.
Yes, Your Honor.
Ms. Ritter, are you on? Okay. So I believe I'm gonna handle that second. And counsel, I have a heavy day and I need to take a break to get ready on 3 sentences. So I'm just letting you know, be patient with it. Okay.
Always, Your Honor.
All right, and then Mr. Hill, I want to believe that you were here on May's McBride.
Yes.
So I'm actually gonna take you first. I'm gonna put you ahead because that's an agreement. So I'm actually gonna take you first. Then I'll do Dan second, and then I'll do Mangum third. And then Ms. Ritter, you need to go talk to your witnesses. So what I'll do is, I'll do, good morning, Mr. Sharp.
Your Honor, how are you today?
I'm wonderful, thank you. How are you today?
Judge, now that I see you, I'm doing a lot better.
Oh, thank you, that was so uplifting. It's not gonna get you anything or your client. That was so.
It's just how I'm feeling, Judge. Just how I'm feeling. That's good.
And I needed that. Look, I needed that. I needed that, cause it's only 9:40 and they're wearing me down already. Okay. So you have a sentencing, your client is here. Did you receive the pre-sentence report?
Yes, Your Honor, we're all ready to go whenever the court's ready.
Okay, so, I don't understand. Where did Michael Clay just come from? How did he just pop up on my screen? Did you all speak to Michael Clay this evening?
I don't think so, Your Honor.
Let me put him in wait while I figure that out. Okay, so this is what I'm gonna do. I am going to handle the 3 cases that I just said, and then Mr. Sharp, I have to take a break because I did not prepare for the sentencing today. I'm gonna take a break and just sit here and read those pre-sentence investigations, then I'll be back with you. But did you need to speak to your client?
No, we spoke yesterday. We're fine, Judge. Thank you.
Okay, so if you give me about 15 minutes, Mr. Sharp, I'll be ready for you in about 15 minutes, okay?
No problem. Whenever you're ready, I'm ready. Thank you.
All right, thank you. I said, yeah, don't tell me nothing about none of this. I'm coming until 11 o'clock. I don't want to hear nothing about none. I said 11 o'clock. Okay, thank you. I just so excited to be present today. All right, Mr. Hill, let me bring in Mays McBurrow. So again, I'm getting ready to do Mays McBurrow, Dan, and then Mangum, and then take a break, read my PSI, and then I'm ready. Okay. So Mangum. And when I take a break, you can go into the breakout room with your witness.
I have a witness on that.
Oh. Okay, go ahead.
Now?
Yeah. Okay, just a little snafu. She has to go in the breakout room to talk to her witness on Magnum. And so just, oh wait, no, I'm doing Mays McBurrows first. Let's do Mays McBurrows first, then you can do the witness on that.
Okay.
Y'all see, I can't. Where did, oh, I was supposed to say where the Mays McBurrows. Okay. And then I think the number was put in the chat just to me.
Yeah, I don't have
So,
it.
yeah, Miss Mays McBurrows, please start your video. Thank you. This is case number 234573001, the people of the state of Michigan versus Mariah Mays McBurrows. Defendant is charged with 1 count of operating with a high BAC, 1 count of operating while intoxicated, 1 count of reckless driving. Today is the date set for an arraignment. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Ryan Hill, P68445 on behalf of May McBurrows. Mariah, state your name for the record. Take yourself off mute, okay?
Mariah Mays McBurrows.
Judge, we'll wait for him reading. Stay on mute.
All right, the court is going to enter not guilty plea. On behalf of Ms. Mays McBurrows, set the matter for pretrial conference. I'll give you the date as to bond.
Judge, my client has no prior criminal history. What I'm asking for is, hang on a second here. I know this is a high BAC case, Judge. My client has no issues in terms of the court wants to impose some type of testing. She's no longer drinking. I know that she is in school right now. And again, no prior. So I'm asking the court based on her lack of criminal history and she's from the area. She's not a flight risk. She did retain us. There was a warrant pending. The court set aside the warrant. She wasn't notified of a court hearing. She is going to appear because we're asking for a personal bond.
Any response from the people?
Your Honor, the people have no objection to a personal bond. We are asking for random urinalysis tested at least twice a month. It looks like the alleged PET results from 2017, which is over 2 times the legal limit.
All right, court is going to set bond in the amount of $5,000 personal bond. No drinking, no driving without a valid license. Additionally, as a condition of bond, Ms. Mays McBurrows is going to submit to random urinalysis twice per month. And that is a condition of your bond. That's a condition of your bond. Mr. Hill, is April 17th a good date for pretrial?
It is, Judge.
All right, court sets the pretrial for April 17th at 8:29. Discovery should be submitted by March 15th. All right, anything further?
Judge, we've already discovered the reason why.
Judge, that's correct. Ms. Ritter, the only thing I was supposed to ask was all the video that you gave us was dash cam. There's no body cam. Could you talk to the OIC, just maybe give us some body cam? What I'm looking for specifically is my client spoke to one of the officers. So if you could just follow up with that, I would greatly appreciate it.
So Judge, it looks like MSP was the arrested agency, so they don't have body worn camera.
They don't?
Well, I think so, okay. So two things I want to address. I'll start with the body worn camera. They don't in general. However, I thought on a different case, and it could have been when I covered felonies, but on a different case, I thought I was made aware that some state troopers have body worn camera, that they're starting to perhaps institute body worn cameras. So you can inquire as to whether and because I think I remember saying that now I needed to have you all place on the record that officer didn't have body worn camera. Okay, so I don't think they all do, Mr. Hill, but I think some of them do. They have dash cam, but I think they have body cam. And so then, that being the case with respect to the discovery already being submitted, did you all want an earlier date? Because I gave that later date so that they could get discovery to you, but if that date is still fine, we can keep it.
Whatever the court wants. If that's all we have and Ms. Ritter confirms that, I'm okay with an earlier date.
I mean.
Judge, we can leave it.
Leave it? Okay.
Yeah.
Okay, and then so Ms. Ritter, I guess what I want then is for you to submit either the body camera, or if MSP sends you something saying they don't have it, send that to Mr. Hill, because I think I was made aware that they're starting to use body worn.
The people can do that.
Okay, all right, then we're all set unless there's something else for the record.
No, thank you.
Can you just put me in a breakout room with my client, Judge, so I can kind of explain everything and we'll just leave from there?
Yes.
Thank you.
Okay, so Ms. Mays McBurrows accept to join breakout room number 15. Ms. Ritter, you can go in and talk to your client. That means I'm ready on, I mean, not your clients, you the prosecutor, I'm sorry. Woo.
Judge, thank you. Good to see you. Bye-bye.
You too. Okay, so Mr. Rams here, she's going in to speak with the witness on your case, but Mr. Kalasta, I'm ready on your case.
All right, we're waiting on an AG and we have an interpreter on this.
They're already here. They've been waiting on you, Mr. Kalasta. I'm gonna let them in now.
Thank you.
Well. Now, did you need to speak with your client, with the interpreter?
No, I spoke to him yesterday.
Okay, thank you. Okay, I'm ready for everyone on the Dan case. I'm ready. So please start your cameras. Mr. Hermes and Mr. Dan, please start your cameras.
Okay, Your Honor.
Thank you so much for your patience this morning. Mr. Hermes, raise your right hand for me, sir. Do you swear or affirm that you will translate from English into Arabic anything I say, counsel says, or The clerk says, and from Arabic into English, anything Mr. Dandan says to the best of your ability?
I do, Your Honor.
Thank you. And state your name for the record, I'm sorry.
Yusuf Hermes, qualified court interpreter in the Arabic language, Your Honor.
Thank you. All right. This is case number 234471301, the people of the state of Michigan versus Sar Dandan.
رقم القضية 230447131 ولاية ميشيغان ضد السيد داندان.
Defendant is charged with one count of gambling, disassociated person, and today is the date set for pretrial conference.
المتهم هو متهم بتهمة أنه هو شخص محظور أن يروح للكاسينو وما كان له حق، واليوم هو محاكمة، جلسة محاكمة قبل المحاكمة.
Appearances, please.
الحضور رجاءً.
Good morning, Your Honor. Caitlin Preblick on behalf of the people, and then I'm being supervised today by Assistant Attorney General Robert Hayes.
أنا كيتلين بري بريك وهي ممثلة المدعي العامة بالنيابة للسيد هيز.
And good morning, Your Honor. Attorney Scott Colassa on behalf of Sar Dandan.
وأنا اسمي سكوت كولاسا بالنيابة للسيد سار داندان.
And Mr. Dandan, please state your name.
سيد داندان قل اسمك للمحكمة رجاءً.
سار دندن.
سار داندان.
Okay, today is the date set for the pretrial. Mr. Kalasa, how are we proceeding?
تقول اليوم هو موعد جلسة قبل المحاكمة. السيد كولاسا تقول لك كيف تريد تبدأ نباشر بالجلسة اليوم.
Yes, Your Honor. Today we are here because Mr. Dandan was offered a problem-gambling diversion program.
اليوم كان عنده أنه كان مقدم عرض من المحكمة للسيد داندان أنه عرض انفصالي.
I have reviewed the documents sent by the AG's office with Mr. Dandan.
وراجعت العرض المقدم من المدعي العام مع السيد داندان.
Those documents have been filled out, signed, and sent to the Attorney General's office.
وهذه الأوراق والاستمارات كانت والوثائق موقعة وأرسلنا لها إلى المدعي العام.
My understanding is that the Attorney General's office would be moving to dismiss without prejudice so that he may enter the program.
I'm sorry, you broke up.
My understanding is that the Attorney General's office will be moving to dismiss without prejudice.
It seems everything froze on my part.
He said the prosecutor's office will be moving to dismiss without prejudice.
أنت تقول أن المدعي العام حيسقط هذه القضية من دون أي تحيز.
That is all.
هذا كل ما عندي.
Ms. Preblick.
Yes, Your Honor, that is the people's understanding as well. And with the completion of diversion, we ask that the case would be dismissed.
نعم، هذا هو ما نفهمه من ناحية المدعي العام، وأنه إذا كمل هذا البرنامج الانحرافي دايفرجن حنسقط القضية ونلغيها ضد السيد داندان.
Give me one moment.
أعطيني لحظة.
Can somebody tell Mr. Dandan to stop unmuting himself? I mean, Mr. Hermes, ask him to stop unmuting himself.
أوكي. وقف أنه أنت سيد داندان لا تحاول تفتح الصوت وتغلق الصوت، خلي الصوت مفتوح.
Okay. All right, so today is the day set for the pretrial. The people have indicated that Mr. Dandan is successfully enrolled in the diversion program, and therefore they will dismiss the case without prejudice.
أوكي. نعرف أنه السيد داندان وقع وشارك مضى أوراق أنه حيشارك بهذا برنامج الانحرافي اللي بيسموه دايفرجن، وبإكمال هذا المنهاج البرنامج نسقط القضية ونلغيها ضد السيد داندان. Go ahead.
He keeps unmuting himself. Can he please stop unmuting himself?
اوكي تقول لك اغلق الصوت رجاء سيد داندان، اغلق الصوت وخليه مسدود، اغلق الصوت خليه مغلوق. اوكي.
Who is going to submit the order of dismissal to the court?
مين اللي قدم طلب الإقصاء القضية وإسقاط القضية للمحكمة؟
We can, Your Honor.
احنا نقدر نستطيع أن نعمل هذا الشيء، المدعي العامة قالت.
Okay, then I'll get the order from the prosecutor, and then Mr. Colasso, we will email a copy for you, and you can get that copy to your client.
اوكي، احنا انت راح تعطيها للمدعي العام والمدعي العام يعطيها للمحكمة والمحكمة تعطيها للسيد كلاسة.
Your Honor, is there a way that I can get a certified copy, or would I just have to go through the clerk's office?
There's no certified copy. I don't even know what's a certified copy. What do you mean? You mean a true copy?
Yes.
You can get that from the clerk, but he can't email you a true copy. You have to come in and get a true copy.
إذا تريد النسخة الأصلية يجب من المحكمة، يجب أن تأتي إلى المحكمة، تقول للمحامي تبعك أنه يروح للمحكمة ليأخذ نسخة أصلية من هذا القرار. Thank you.
Understood. I'll take care of that.
مفهوم، وأنا سأعمل هذا.
All right, we're all set then. Everyone have a great day. Stay safe.
Thank you, Your Honor.
انتهت القضية، تقول الله معك. Thank you, Your Honor.
Thank you, Mr. Thank you, Your Honor.
Because that ain't.
And she doesn't know, right?
Yep.
She's.
Okay, are we ready on Mangum? And I need everyone to stay muted except the lawyer until you're asked to unmute. Stay muted until you're asked to unmute. Did you say Mr. Reeves, is the case he wants it now? I don't care about Mr. Brown. Mr. Brown had a 902 appointment. I don't need to talk to Mr. Brown, and I don't need any message from Mr. Brown. All I need is for Mr. Brown to be at that door. So I don't. All right, are we ready? We're ready on Mangum. This is, I mean, I literally said, okay. Can you all hear me? Can you all hear me?
Yes.
Okay, I literally said, do not unmute yourself until you're asked to do so by the court. I literally said that. Mr. Ramsey, I'm gonna send your client in with you because apparently she's having issues.
Thank you, Your Honor.
So I'll send you to a breakout. Okay, then that means we're not quite ready on that case. But this is the point that I was taking my break so I could get ready on the sentencing. So I want to, Ms. Gerard, I'll put you back in the waiting room until we're ready. Literally going to this breakout room. Ms. Stevenson.
Yes, Your Honor.
Go to the breakout room with Mr. Ramsey. Tell him he needs to this client, because they might need to come in person. She's not, her system is working.
Yes, Your Honor.
Thank you. I appreciate it. I'm on break so I can read these. I wanna. Ms. Mangum, please start your video, please. Ms. Mangum, start your video, please. Okay, council, you all have to come in person. I don't know what else to tell you. Can you unmute? Did you call your client?
I apologize, Your Honor. I did call my client. I had her sign out and sign back in to see if that worked.
Well, it's not working. And this, I'm not gonna keep trying. So she has to come in person.
Do you want us there this morning, Your Honor?
I'm here. You can, I mean, I don't know what her situation is.
All right, I'll have to call her and see if she's able to get down there.
If she's able, you say if she's able to get down to court on her court date.
I'm gonna try and get her down there. Your Honor.
I'm gonna repeat what you said. I was asking. You said you're gonna call and ask your client if she's able. Are you gonna tell her to get down to court for her
I'll tell her
court
to
date?
get down there, Your Honor.
Oh, I was wondering.
I will see you down there shortly.
Okay. Mr. Gerard, you can do a couple of things. You can continue to hang tight, or we can record that you have appeared. I am live streaming on YouTube, so if you want to just go on YouTube, and I am live streaming. But if you don't want to just have to keep sitting and waiting or whatever, and the live stream will also, you know, it'll be up at least probably until tomorrow, unless I make a mistake and do something, like, show something I'm not supposed to show, then I'll take it down right away. So it's up to you, but she's not, her video is, I mean, her device is taking too much time on my document.
So do I have to go to court?
You already in court right now. I'm
right,
telling you, you can stay on the Zoom. I can put you in the waiting room. You can stay on Zoom and wait for her to get down to court, or you can log off. Ms. Ritter will tell you that- you're talking over me, sir. You're talking over me. Or you can log off and Ms. Ritter can let you know what occurred, or you can go and turn on your YouTube and you can watch it on YouTube. So those are your three choices.
Okay, well, I'm gonna have to watch it on YouTube because I have to go to work, so I can't hang on for, because I don't know how long this is.
Go ahead and go to work and Ms. Ritter will let you know what happened, okay?
All right, thank you, Your Honor.
Okay, you're welcome. Have a great day, stay safe.
You too, thank you.
Counsel, you and your client can come on down, okay? Mr. McCready, good morning, I think you were here for that case, so as you see, it's gonna be delayed. He not here either, okay, I'm ready on Mayweather.
Ready on Daryl Mayweather, Your Honor.
No, Ms. Ritter, you could say, oh, you trying to distance yourself, just, you're not even, okay. You're trying to blame on us that you got sick. No, that was probably you out in the street. This is case number. Case number 23447-2601, the people versus Daryl. And I think the middle name, yes, is, DeVette Mayweather. Defendant is charged with 1 count of assault or assault and battery, and today's the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Rivera, on behalf of the people.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Daryl Mayweather. Mr. Mayweather, sir, please tell the judge your full name.
Daryl Mayweather,
What's your middle name?
Daryl Mayweather.
Thank you. Today is the day set for sentencing. I have now had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
None on behalf of the people that.
On behalf of the defense?
On behalf of Mr. Mayweather, Your Honor, on page 3, we would like to know that Mr. Mayweather, we would like the court to know that Mr. Mayweather does have a valid operator's license from the state, issued by the state of Texas, and I'll speak to that in a moment.
And that means it's not valid in Michigan if he's been living here for 30 days. You
Understood, Your
can't have a license and live in another state. You're supposed to change your license in 30 days. So that means he's not valid in Michigan.
Understood, Your Honor. In addition, Your Honor, on page 5, in the employment section, Mr. Mayweather indicates that he is employed at WmOVTEbOw9w in Plymouth, Your Honor, that the hourly rate is $17 per hour. With regard to the DT real estate, Mr. Mayweather has advised me that he did not report that he averages $50,000 every 6 months. He's indicated that.
Can you call Mr. I'm sorry, Ms. Bumpus asked her to come into the courtroom. Go ahead, Ms. Gleason.
He's indicated that he did not report that he's a licensed real estate agent. He does purchase homes and refurbish them, Your Honor. He did at some point have approximately, well, actually, I would scratch that. Mr. Mayweather did have was the owner of the property where the incident that he's pled guilty to did occur. He has since lost that home. That was a rental property and he no longer owns that property. So right now he doesn't have any income through the refurbishing of the homes. And he did not report that he's a licensed real estate agent. In addition, Your Honor, let's see. So down to the evaluation and plan section on page 7, in that second full, it looks like a paragraph, the second line, again, Mr. Mayweather indicates that he did not report that he's a licensed real estate agent. And also, Mr. Mayweather, in that same paragraph, 1, 2, 3, 4 lines from the bottom, the sentence begins, the defendant reported he does not have a medical marijuana card. Mr. Mayweather indicates that he does have a medical marijuana card. Other than that, Your Honor, well, so in the personal history, I'm sorry to jump back, but on page 5, in the personal history current resident section, and previous resident section. So at the time of this incident, Mr. Mayweather was living in the state of Texas. Once this case opened, he was directed not to leave the state of Michigan, and he's been here since the time of his arraignment, Your Honor. So Mr. Mayweather actually, his current residence is in the state of Texas, but he maintains a home at that Stout address in the city of Detroit. Other than that, we have no additions, deletions, or corrections, and Mr. Mayweather does stand ready for sentencing.
On behalf of the people.
Nothing as far as sentencing on behalf of the people.
On behalf of the defense.
On behalf of Mr. Mayweather, Your Honor, we would like the court to take note of the fact that Mr. Mayweather, I believe as he did report, is helping to support his wife who's receiving cancer treatment here in the state of Michigan. And that's why he's maintaining the home in the city of Detroit. He would be asking the court for permission at this point to be able to return to the state of Texas because his children are there. They're currently, and they have been for the last several weeks at this point, in the care of their aunt and their grandmother. Prior to this incident, Mr. Mayweather and his family would travel back and forth between Michigan and Texas so that his wife could get that cancer treatment. But he is asking the court to give him permission to travel back and forth between Texas and Michigan so that he can get back there and relieve his mother and his sister of their child care for his own children. Mr. Mayweather, I believe, would like to address the court, Your Honor, with regard to the sentencing and with regard to how he would hope that this court would handle this matter.
All right, Mr. Mayweather.
Yes. How you doing, Honor? My name is Daryl Mayweather. I ain't been in trouble since 15 years. My wife on cancer, I do have paper. I cut my finger off on the job in Texas. So I marijuana, I lost my license because I got locked up for the incident. So I got proof of my paper. I come back to Detroit to buy houses for single women. So this incident, it's the kids, she's 16, one is a 16-year-old, she had a baby, and the other daughter. So I rented my house off to them because the mother didn't want them in there. They was in a hotel. I'm sorry that the mother was there. She was in a wheelchair. She threatened me, she pulled up on me. I did. I ain't no excuse. I turned the chair around and said, I don't want that negativity because you in my household. I'm doing this for your kids. I'm sorry that I did do that. Ain't no excuses. But I'm a good man. I'm doing this for the ladies. I ain't been in no trouble. I'm coming correct. I go back and forth to Texas. I work on the weekends because the medicine for my wife is expensive. It's very expensive. She go to Henry Ford to do her treatments. All I'm asking, can I get a legacy of being a good citizen for? I'm not a criminal, and I'm asking, don't take my past because that's what a lot of people do 15 years ago and put it on my future. I'm doing right. I'm doing the right thing. So now I'm asking, can I get it? No drugs, unsupervised. Just I pay my fine. If I got to take the anger management class, I'll do that. But as far as everything, I'm not a criminal. I'm not a bad guy. I don't do none of that crazy stuff these young guys are hurting me. I really don't. It's been over 15 years since you've ever seen me in the jail cell. And I'm coming with proof. I'm coming correct because I know what I'm looking at. I know what you're going through. I just want to be on the good side. I'm coming correct. I'm buying houses. Detroit got the cheapest market besides Texas. Coming and paying, buying them up, fixing them up, and giving young ladies a chance to rent for low income. Yes, I'm not an unlicensed. I'm doing this as an independent guy. I make $35,000 a year on Rebosco. Now the conversation me and Ms. Buckman had, the $50,000, and that might be out there that she talked about the job is $35,000. I come by the house, I rent out for $800 for rent to the ladies. They tell you that. She came, you said no contact. She came not too long ago, pulled on me, apologized to me because she threatened me. But I say I was wrong for turning the chair. I ain't no excuses for that. I'm not a negative person. I don't do none of that. I got too much going on for my wife. I ain't got time to be, and I'm trying to help out other people at the same time. And then I'm going back and forth from home. Okay, you said the Michigan license. I have Texas license. That's where I live at. I come in here to Detroit and I'm trying to take over as a black man the real estate. A lot of people got these loans. They ain't doing nothing. Want to be fresh to death about shoot. I'm trying to buy houses. Cause you can't get into Texas for $35,000, $1,500. You can't get that. Here in Detroit, I'm trying to take advantage of it. Get out of my past. I used to sell drugs. People don't see all that weed. You see the case. I'll take that mind frame. Why go buy weeds and cocaine? I mean, I go buy this house for $25,000, $35,000 and fix it up and rent it out. Well, sell it. That's what my mind at. I ain't been in jail and never been touched since over 15 years. And this one case, Even though she said she was wrong, that's why she didn't press charge nothing. I don't want no smoke. I don't want none of that. My life, I got a lot of things positive going on. Now, if I just got locked up 3, 4, 5 years ago for some crazy stuff, I understand that you do right to do what you got to do. But we're talking about over 15 years. I just ain't trying to mess my life back up off my past. A lot of people going off the past. Look at my future, look what I'm doing now. That's all I gotta say on it. And I'm sorry for the incident.
Okay. Okay, the court is ready to impose sentence. I will do so in the following manner. There is a recommendation from probation, for a probationary period. Also, I believe that's also the recommendation from from the prosecutor. And I did look at, the recommendation from probation, Mr. Mayweather, and at first I wasn't going to accept it because I saw the criminal history. They had recommended 12 months, and then I was like, no, I'm not going to do 12 months. But then I did see that was a long time ago, your criminal history, and you are correct. You haven't been in trouble for a long time. So I had already, based on some other things, I had already decided, I guess. Well, I shouldn't say I decided, because had the victim been here and said something different, I might consider something different as well. But so I am going to accept the recommendation for a 12-month probationary period. That would give us a final review date of January the 31st, 2025. Of course, based on legislation, you would have an opportunity for early discharge after 6 months. So I will give you a review date of July. Strike it. Let's come back August 6th. I'll give you. Wait a minute. That sound like. I won't be there. When I put that trial on the 6th. We're gonna give you a review date for August the 8th. If you have completed the terms and conditions of your probation, you will be eligible for discharge at that time. The terms and conditions of your probation are as follows. You shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan or Texas without consent of the court. I am going to allow you to go between Texas and Michigan. However, that's it, like Texas and Michigan. So if you leave in Texas, if you're gonna drive, you need to let us know, because if you get a ticket somewhere between Michigan and Texas, then that's gonna be a violation. But just let us know. So I'm saying to drive from Texas to Michigan, but all right. You must notify probation of any change of your address, phone number, or employment status. You will pay the following fines, costs, and fees: $210 mandatory cost. I'm gonna reserve the amount of the attorney fee until I hear from Ms. Bumpus. That's why I was trying to hear from Ms. Bumpus. Because even with his own, I guess, explanation as to what he does, he may or may not. I don't know how many children he has. Well, yes, I do, because it's on the sheet, I think. But I need to hear from this. Oh, she's on her way. Okay. So I'm gonna see what she says before I decide how much the attorney's fee will be. And then I am gonna impose a $200 fine. I don't believe there's any restitution, Ms. Ritter.
No, Your Honor.
0 restitution, $420 supervision fees at a rate of $35 per month. $50 precinct investigation fee. This is where I also I was confused, not that it had a much of an impact except as to my judging Mr. Mayweather's credibility. So on page 6, on the substance abuse use and treatment section, the first line, it says alcohol, and then it said defendant reported he has not consumed alcohol. And then under the comment section, it says he was referred to ATS for drug screening, and he tested positive for alcohol. Now, so something not right in the Kool-Aid right there. You can't say I didn't drink alcohol, then you test positive for alcohol, so that's something that's not right in Kool-Aid. That make me, come on up, Ms. Bumpus, that makes me, we just leery of his veracity, his veracity, his truth of veracity. So, I am going to order that he submit to your analysis. Now he said, Mr. Mayweather, you held up some papers too about your marijuana.
Yes, ma'am.
All right, pass those to Ms. Bumpus. And then Ms. Bumpus, good morning.
Good morning, Your Honor.
Thank you for coming. The reason I asked you to come is because Mr. Mayweather, contradicts your, statement on page 5 of the report under employment. He says, well, two things. One, he said his rate of pay at Bosco is $17 an hour, but that's not my issue because that could be, I don't know. But it's the real estate part. He says he admits today that he purchases houses and flips them, I guess, or whatever. He said he didn't tell you that he's a licensed real estate agent, nor that he made $50,000 every 6 months. How did you come up with that?
For the record, Your Honor, Lord, on behalf of the probation department, Your Honor, I did inquire as to whether or not he was a licensed real estate agent. He did tell me that he was. He did not submit proof of it. And I asked him, well, how much on average do you make? And he gave me an average figure. It's just an average, every 6 months, $50,000.
So he did tell you that?
Yes, and he told me that he did flip houses.
Okay, but hold on, Mr. Mayor, because again, veracity. You saying you didn't tell her that. That made me think she would have made it up. And I was thinking that maybe she thought it was a different case and she put it on the wrong case. But it sounded like to me she remembered the conversation.
May I say?
Yes.
So that's what I was saying, that when I say I do flip houses, when I was talking about with Bosco, it's not the 50,000 for the real estate. It's 35,000 every year.
This is my script
for
on the interview you had. And it says $22.75 from Obasco. It's a summary of the company. $22.75 is on my script.
Mm-hmm.
And he's a LLC. He buys homes and fixes them up. And it was called DT
Real estate. Mm-hmm.
That's what
okay.
I wrote it clearly on my script.
And then what about that average $50,000 every 6 months?
That's what he told me.
That's not.
I mean, you was trying to impress Ms. Bumpus?
That's not true.
Hold on.
Oh, you did.
At the time, you was just trying to impress Ms. Bumpus. You didn't know I was gonna use it.
Oh, no.
Hey, I'm not gonna sit up here and do all that, no, because I've been through them now, kid. I'm not gonna do that. That's why I said the conversation must have been on me that far. The money wise, when we was talking, I'm thinking we talk about Bosco. But I explained to her, I do buy houses, I flip houses. I ain't lying about that. But $50,000 every 6 months, I wish I could make $50,000 every 6 months.
I told him I know with real estate license, there's not a set amount that you make,
Mhm.
just give me an average on how much.
Yeah.
That's what.
Okay.
That's my, and I'll take that on my behalf.
All right, court is going to assess, Ms. Stevenson, at what stage in the process did he plead?
At final pretrial, I believe, Your Honor.
All right. Court is gonna set a $500 attorney's fee. Total fines, costs, and fees. Now, y'all, why y'all two talking? Hold on. What did I say about his urine screen? Oh, because you said that you didn't drink, but then you did drink. So I am gonna order urine screening for the first 6 months. Once a month, that's $60 if you come here, but if you text, let me be clear. I'm letting you go to Texas, but I don't care if it costs $200 to drug test in Texas. That's between you and Ms. Bumpus to set it up. So I think you said your wife has to come here, you know, for her test, but the problem with that is, here's the problem. Drug testing is supposed to be random. So I don't want anybody planning for a drug test, right? So drug tests are supposed to be random. So if Ms. Bumpus tells you got a test, but you in Texas, then you gotta go to the lab in Texas. I don't want any scheduled drug tests. So you understand what I'm saying? So you can't tell Ms. Bumpus, oh, well, me and my wife gonna be in town on this day. Can I do a drug test? No. The answer is no. If we doing it at the lab, however the lab does it, if they call you and you're in town, then you come to the 36th District Court lab. But if they call you and you're not in town, you're gonna go wherever Ms. Bumpus has already approved for you to go. That's how that's gonna work, okay? Okay.
Your Honor.
Yes.
Just for the record, I might not be assigned this case, but I.
Oh, that's right, because you just get the PSI.
I'll relay everything.
Yes, thank you. Okay. All right, and that's all I needed you for, Ms. Bumpus, so thank you.
Thank you, Your Honor. I'm sorry, I was in judge.
Oh, no, they told me. Yes, thank you.
Okay, thank you.
Okay, so the total is $1,380. Wait, I don't know if I added the 60, I did, plus 6. So the total should be $1,440. Now, if you get discharged early at the 6 months, then, you would have to pay $1,230 to get discharged early. Sir, you shall not use or possess any illegal substance. You cannot use or possess any marijuana without a valid medical marijuana card. You cannot use or possess any opiates without a valid prescription, and letter of explanation from the doctor. You cannot drive without a valid driver's license. You shall attend 12 weeks of anger management. Hey, you provide proof of your education or participate in an adult education GED program. Attend the Choices program through eBay. Have no contact with Mary Klein. I'm not going to order the community service at this particular time. And I believe I covered all. They also recommended marijuana insight, but I'm not going to order it. He has a medical marijuana card. Anything further?
No, thank you.
I don't have anything further. Mr. Mayweather, did you have anything else for the court?
Where do I pay the money at?
Oh, you can talk to probation about that.
Okay. That's it.
Y'all not being honest. Why y'all saying they do? It's okay. Why? That's not my rule. So, but that's not my rule though. Let's make sure we follow my rules. They gotta sit in here. They gotta sit in here. Okay, are you able to do this probation order now?
I can't.
All right, I want you to have a seat in the hall, Mr. Mayweather, and wait for your order of probation while you're here, okay?
Yes, ma'am.
And they'll tell you how to pay that.
Okay, thank you.
You're welcome.
Thank you.
I'm ready on Townsend.
Ready on Townsend, Your Honor.
This is case number 224558501, the People versus Deborah Dolores Townsend. Defendant is charged with 1 count of gambling, disassociated person. Today is the day set for, this is a mess. I'm not ready on Townsend. Have a seat. Call the AG's office back. They gotta be here on Townsend. It wasn't calling back. Why not working? Okay, I need the AG's office. Oh, all right. Oh, okay. Where is that? And I'm not, I don't see it anymore. I'm looking probably right at it. Oh, here it is. Here it is. Good morning, Ms. Barrett. Again.
Good morning, Judge.
All right, your client is in person.
Okay, good.
I'm gonna take Ms. Urell, and then I'm ready for you, Mr. Shark. I don't know if you're there on Kellis. All right, I'm ready on Urell. All right, this is case number 224557001, People versus Sierra Renee Urell. Defendant is charged with 1 count of assault or assault and battery. Today is the day set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Judge. Melita Baird on behalf of Sierra Urell. Judge, there is a great possibility we could.
Can you put your P number on the record?
43238.
Ms. Urell, state your name. Sierra Urell. And is your middle name Renee? Ms. Barrett?
Yes, Judge.
You can go ahead. What were you saying?
I spoke with Mr. Urell. I haven't had a chance to speak with the prosecutor, but we're not trying to really take this to a trial. If I can talk to the prosecutor, Judge, I probably can work something out short of a bench or jury trial. That's not her desire at this time.
Oh, well, you can't help the prosecutor right here in the courtroom, Ms. Barrett. So you saying you want a continuance or?
Yes, Judge. Yes, Judge. What day can I come in there?
Is it, you can't come in here today?
Today? Did you say?
I'm just gonna be honest with you. Every time I bring your client back, is a chance for her to go, another chance to go south. Now, at least twice on Zoom, I was gonna lock your client up. So if we can get it done today, that would be better, because every time I bring your client back is a chance for her to, it goes south. So I don't know, maybe when I do, maybe let's at least do this. Maybe when I do the sentencing for Miss Townsend, because it's the AG's case, maybe you can call Miss Ritter and you all can talk on the phone and we can see if we can settle it today, because I do not, it seemed like you're kind of in a good mood, in a good place today. And I want to capitalize on that momentum.
Well, Judge, that sounds good. Like I explained to the court earlier, I've been talking to her and I think she has a better understanding of what's going on around here right now. So if you give me that phone number, I will
You
call.
what she needed the whole time. I mean, I just gonna applaud you. She ain't here laughing. I don't even know if you can see her. You must be what she needed. And cause Miss Barrett, let me tell you the truth of something. I'm gonna be transparent in a minute. Now, and Miss Steve said she be low key, she be kind of calm sometimes, but sometimes that I know she connect with the other side of me too. And so then Miss Barrett, I'm gonna tell you the truth, Miss Barrett, when they told me who Miss Carter had appointed for Miss Sherelle case, I said, I don't know. I said, Miss Barrett is like low, you calm and stuff. But I mean, I don't be seeing you, I said, and then I said, I don't know if she gonna be able to. You know I'm right, Miss Sherelle know I'm right. This is the first time, Miss Barrett, let me say something. Oh, I wish you was in person, Miss Barrett, because when I'm telling you this the first time, and we on lawyer number 3. This the first time I seen Miss Urell smile. Oh my goodness, I'm so excited right now. So let's do this. Miss Urell gonna have a seat, and we gonna get the AG's office in here, and then you can talk to Miss. I'm so excited. You can talk to Miss Barrett. Let me tell you this too, Miss Barrett. Your points have gone up exponentially. Like I didn't even have any negative thought of you or anything like that. But there's a person, and I call him the anger management whisperer, Mr. Rice. I've never met him, and he runs this program. But when I see the defendants come back in and they're like totally different after they've been to him, I'm like, he is just like my hero. Miss Barrett, you get ready to be my oh my goodness, you get ready to be another hero. Okay, Miss hero, I'm gonna stop. Not that much. It was not that much. Miss Sherelle, Miss Sherelle, can I read you something? Do you mind if I read you something? Do you mind? Okay. You said you're not that much. That's what you just said. Miss Sherelle, one of my colleagues, I will allow them to remain anonymous. Not one of my 36 district court colleagues, one of my circuit court colleagues texted me. And I haven't spoken with her this year. She texted me because we go live and stuff, and then the people illegally rebroadcast us sometimes. Okay. She texted me yesterday. She must have been watching some stuff, and she said, Happy New Year. I applaud how you handled Miss Urell, who was clearly having a bad day. Now, Miss Urell, you said you're not that much. I'm not. Miss Barrett has done an amazing job. I'm excited for me and you. So I'm gonna stop messing with you. Have a seat. Let me get this other case, and then we're gonna see if we can handle it today. But if not, If not, don't act like you didn't do nothing different today. Mr. Earl, go ahead. Please.
Judge, were
Okay.
you gonna give me that phone number?
For Miss Ritter,
Yes.
yes, she's gonna get your phone number. What phone number you want? She got 2 and 3 phones to currently get. She thinking she's something out here. She's gonna put it in the chat to you, Miss Barrett. Her county
Okay, thank
phone.
you.
Okay. Mr. Earl, you remember what you said to me last time? You said. Let me know. Okay. Look, hi again, Miss Presley. Hi, Miss Presley. Did you go on, was that you earlier?
It was, Your Honor.
Because listen, the day is just, this is an amazing day. It's something about today. I need your supervisor so we can, you all didn't know you had a sentencing today?
Oh, yes, we do, Your Honor. I'm sorry. We must have hopped off too soon. I have it on my calendar. I wasn't even thinking.
Yes, Miss Townsend. So I had caught the case, but you all weren't here. One of your supervisors could just pop on, because I think I would be breaking the rules if I let you do it by yourself. Now, we both know that I think you're more than able to do this by yourself, but and I don't think I can let the defense attorney supervise you. That wouldn't be right.
No, let me see if Mr. Hayes can hop back on quick. If not, I can grab someone else.
Okay, thank you. Okay. Whew. Mr. Shark, are you there? I don't know if something's wrong with your video because you're not on. I'm not even stressed no more. This has been. And then, what does your shirt say? Let me see. Let me see. Because it is the truth. And that last part. Oh, black gifted. You don't even know, you didn't even know what shirt you put on.
I woke up late, I was trying to rush down.
Oh, yeah, because we get ready. I told him, I don't want no messages from Miss,
She told me to hop on Zoom, I called 36, I said, yeah, my lawyer said hop on Zoom, but am I supposed to still come down there?
Oh, yeah, she didn't know, your lawyer didn't know. Your lawyer didn't know, you couldn't hop on Zoom, give your life.
The clerk had gave me your clerk office number.
Oh, yeah, well, I'm glad you came in person. Mr. Kelly, is Mr. Sharp, he must be doing something else. Okay, your lawyer might have had to go on another court hearing, but I'm gonna leave you here. And then when he turns on his camera, then we'll be ready, okay?
Okay, yes, ma'am.
All right. Okay, well, let's go ahead and do, oh, Mangum is here, but her lawyer isn't here yet. Okay. Let me do some of these other ones. I have a complaint. On which one? Okay, well. All right, Ms. Stevenson, I'm ready on Glover.
Ready on Glover, Your Honor.
Oh, yes, it's a work, okay. I'm ready on Glover. Can Ms. Reed and Ms. Glover start your cameras? All right. Please stay muted until you're asked to unmute. Please stay muted. This is case number 22453-0201. The people versus Deanna Jackie Glover. Defendant is charged with 1 count of assault aggravated. Today is the day set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people. I have the complaint witness present via Zoom this morning. Ms. Reed, can you unmute yourself and say your name for the court?
Renee Reed.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Deanna Glover. Ms. Glover, ma'am, please unmute and say your full name.
Deanna Glover.
Ms. Glover, what's your middle name, please?
Jackie. Deanna Jackie Glover.
Today is the day set for final pretrial conference. How are we proceeding?
Thank you, Your Honor. Ms. Glover will continue her plea of not guilty. Your Honor, I believe this matter is scheduled for jury trial. I want to say April 2nd, Your Honor, but Ms. Glover wishes to waive her rights incident to jury trial, asks that the matter be heard by this court.
Can you tell me when the jury trial, I'm sorry, not jury trial. The final jury trial is for Shannon. On it today. No. The court is going to continue a not guilty plea on your behalf. Ms. Glover, set the matter for a waiver trial. Well, strike that. Set the matter for trial or continue the matter to trial. With respect to that trial, Ms. Glover, your lawyer, by her words, has indicated that you want to waive your right to a jury trial and have the case heard by the court, meaning by me. Is that what you want to do?
Yes, ma'am. Yes, sir, Your Honor.
Do you understand that if I accept this waiver from you today, that you will not have a jury to hear the case, that I will be the only decision maker? Do you understand that?
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to waive your right to a jury and have me hear the case?
No, Your Honor.
Any objection from the people?
No objection, Judge.
Having no objection from the people, finding that the waiver has been made freely, knowingly, and voluntarily, the court accepts the waiver. And I will continue the matter to a waiver trial. We're going to change the date from April the 2nd to April the 1st. At 10:30. In person at 36 District Court. Anything further?
Nothing, Judge.
Nothing on behalf of Ms. Glover. Thank you, Your Honor.
All right, then, Ms. Glover, and you're all set until, okay, hold on, I'm sorry. Do we need a final retrial before that day?
The people don't judge.
Fence does not, Your Honor.
All right, then, ladies, you're all set until April 1st at 10:30, courtroom 339, 36 District Court. Have a great day, stay safe.
Thank you.
You're welcome. Mr. Shark, I am waiting on you to start your camera to let me know that you're ready. But in the meantime, I'm gonna do Bahorsky and where's the other person that I'm in? I thought I did it. I thought I did it Otis. If nobody sees Otis on the screen.
He's at the top.
Where? He's at the top of your screen?
Antara model. He's in the waiting.
Oh, I didn't know. Okay. All right, I'm ready on Bahorsky. This is case number 194428601, People versus Shannon Lee Bahorsky. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Please the court, Abdullah Mugni here on behalf of Shannon Bahorsky, who appears today via Zoom. Shannon, could you please unmute your microphone and say your full name for the record?
Shannon Lee Bahorsky.
I need everybody to listen. I need you to listen. I need you to listen. I need everybody to listen. Okay, so Ms. Bohorsky, state your name for the court.
Shannon Lee Bohorsky.
Today is the day set for a pretrial conference. How are we proceeding?
Your Honor, on behalf of the defendant, we are going to move for a dismissal based on the complaining witness's failure to appear.
Ms. Ritter.
Judge, this at least the second scheduling of the pre-trial conference, and I don't see the complaining witness Deja back in the waiting room. She has not checked in person. At this time, after people are not going to proceed based on the complaining witness's failure to appear.
Today is the day set for pre-trial conference. The complaining witness was required to appear. They failed to appear. The people have no explanation. They are unable to proceed. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Ms. Bohorsky, we will mail you a copy of the order of dismissal for your records, ma'am. Have a great day and stay safe.
Thank you. Have a good day.
Thank you. Ready on Otis. This is case number 234537501. The people of the state of Michigan versus Antar Ahmad Otis. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
May it please the court, Abdullah Mugni here on behalf of Antar Otis, who appears today via Zoom. Antar, could you please unmute your microphone and say your full name for the record? Unmute your microphone, please.
Antar Ahmad Otis.
Today is the day set for pretrial. How are we proceeding?
Your Honor, today we're going to move for a dismissal based on the complaining witness's failure to appear.
Ms. Ritter.
So, Your Honor, the complaining witness in this matter was actually a 17-year-old student at Central High School where the incident took place. I believe Otis was the security guard. So with that being said, Judge, due to the fact that the complaining witness is a minor, we're going to ask the court to deny the defense counsel's motion and proceed to a final pretrial.
Court is going to deny defense counsel's motion. How do you wish to proceed?
Your Honor, we ask that this be set for a final pretrial and request all discovery on the matter.
Court is going to plead but not guilty please and continue the matter to final pretrial conference. Court will set a final pretrial conference. April 17th. Discovery is due by March 15th. Bond will continue. Anything further?
No, thank you, Judge.
No, thanks, Your Honor.
All right, then, Mr. Otis, we're all set until April 17th at 9:00 a.m.
Yes, ma'am.
Have a great day. Stay safe.
Thank you.
All right, you're welcome. Ms. Barrett, you can call Ms. Ritter now. Still waiting on Mr. Sharp. Okay, Ms. Frederick and Mr. Hayes, I'm ready. On this arrangement on this one, is it probation or something? All right, ma'am, I'm ready. Come on. And then while I'm doing this, I guess I can bring in some people. No, that's take too much time. I'm bringing in a minute. All right, I'm ready on Townsend. Thank you for your patience, Ms. Townsend. That was the Assistant Attorney General's office forgot they had. This is, I don't know if I called the case previously, so if I did, it's a recall. Okay, but Mr. Hayes, can you turn on your camera? You're trying to get me in trouble. Okay, all right, I see you now. I just want to make sure the recorder caught your face. All right, this is case number 22-4558501, People versus Deborah Townsend. Deborah Dolores Townsend, defendant is charged with 1 count of gambling, disassociated person, trespass. Today is the day set for sentencing. Appearances, please.
Good morning, Your Honor. Caitlin Preblick on behalf of the people, and I'm being supervised today by Assistant Attorney General Robert Hayes.
All right.
For the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Deborah Townsend. Good morning again, Ms. Townsend. Ma'am, please say your full name.
Deborah Dolores Townsend. All right, today's the day set for sentencing. I've had enough. I didn't know I did. Let me stop that. That was my ordinary speech. I didn't reach pre-sentence investigation because I didn't understand why it was ordered when I saw the charge. But if there's something in the pre-sentence investigation that you want to point out to me, because maybe in my absence, Judge Baltimore ordered it at the request of one of you. So I don't know, but I normally don't order them for these cases. So I didn't review it, but if there's something on it that you want to bring to my attention, you may, on behalf of the people.
Nothing directly about the pre-sentencing report on behalf of the people, Your Honor.
On behalf of the defense.
Thank you, Your Honor. Ms. Townsend, thank you for clearing that up, Judge. I was a little bit taken aback by PSI in this case, but
she pled guilty on November 28th. I was on my notes. Okay.
Oh, so we did, despite that, have the opportunity to review the pre-sentence investigation report together. And we don't have any additions, deletions, or corrections, Your Honor.
All right, and then anything from the people with respect to sentencing?
Your Honor, given that this is Ms. Townsend's second dissociated persons trespass, we'd be willing to offer a 771 on this case, with the understanding if she was able to comply with the court's typical orders of Gamblers Anonymous and counseling of that sort. We're not sure I'm not sure, and based on our records, if she has done that since she pled guilty and has done any of those things. But if she would comply with those orders, then we'd be willing to offer a 771.
We thank the people for the 771 offer, and Ms. Townsend absolutely will do everything that she needs to do to benefit from the people's offer. I am asking the court to sentence Ms. Townsend to not more than 9 months probation, Your Honor, with an opportunity to early discharge. I don't know. Actually, I do not believe that Ms. Townsend has done any recent gamblers counseling. She did some pursuant to a prior diversion that I think she participated in. But Ms. Townsend has, I think she's had her name removed from the disassociated persons list, but she isn't caring anything about that. She's staying out of the casinos, understanding the trap that they are. Ms. Townsend, I want to say to her credit, Ms. Townsend got to court pretty early, Your Honor, and would have gotten here even earlier, but for the fact that on her way to court this morning, somebody hit her car. And despite that, she still got down here when she was supposed to, ready to go ahead and take care of this matter. I don't believe that Ms. Townsend is going to have any problems whatsoever being fully compliant with this court's order. And I would ask you to sentence her pursuant to MCLA 771.1 per the people's recommendation.
Would Ms. Townsend like to make a statement on her own behalf?
I just say, you ain't got to worry about me going into casinos no more. And I appreciate whatever, you can do for me.
Mr. Mooney, I don't know if you have a case coming up, but I just sent 3 people to breakout. I need Omari to go to breakout. Okay. All right, court is ready to impose sentence, so as follows. Ms. Townsend, I didn't used to think, when I first got assigned to this docket at my own request, I finally got to go somewhere I wanted to go. And, oh, hold on one second. He said it was time to see. Okay. Last name. Okay, so Ms. Townsend, these cases I used to, be like, what, gambling, that's a crime? But then I began to understand why the legislatures, did what they did, with the exception of why they made it a 1-year misdemeanor. I still don't understand that, but, understanding the snowball effect that could happen when a person is addicted to gambling. It could become a snowball. You can start stealing from your family, you can start stealing from your friends, you can start stealing from the general public to try to, either pay your gambling debts or continue to gamble. So I started understanding it's one of those crimes where not only are they trying to save you from yourself, but they're trying to save the general public from theft and things of that nature. So I began to understand it. Your lawyer has indicated that you've taken yourself off of the disassociated persons list. However, whether you choose to go in, whether you were going to voluntarily go in or not, while the case is pending, while you're on probation, you're still prohibited from entering any Michigan casino, okay? Okay, all right. Don't let I had a trial, don't let the Las Vegas trick you. Okay. If you go to Las Vegas and they give you a form, I think I'm gonna write a letter to them. If you go to Las Vegas, they give you a form and tell you, oh, you can come to the Michigan casino, but don't believe them. Don't believe because they got somebody in trouble. But I'm gonna accept the recommendation for 9-month probation, and I'm gonna accept the recommendation for the delayed sentence. So I will delay the sentence, which means at the conclusion of the probationary period, you will be eligible for not only a discharge, but for a dismissal of the case, removing the conviction from your record. The 9-month date would be October the 31st. However, you will be eligible for discharge at May. Right there, you'll be eligible for discharge for 4.5 months. So you will be eligible for discharge in the middle of June. I'll set a review date for June the 20th. Let me make sure that's there. What if I decide I don't want to come to work after Juneteenth? and I want extra days, so I'm not gonna set my. All right, let's set it for June 18th. And at that time, you will be eligible for early discharge if you complete the following terms and conditions. You shall not violate any criminal law of any governmental unit. That means no new cases. You must not leave the state of Michigan without my consent. You, well, I'm gonna make it reporting, but I'm gonna reduce the oversight fees. And the reason I'm gonna make it reporting is because I've been having some issues with the gambling cases. And I need you all to get referred to a proper place for the Gamblers Anonymous. So I'm gonna make it reporting, but I'm gonna only charge $5 a month for the oversight fee. So, don't judge me when I get my calculator to times 5 times 9. Don't judge. So this is fee of $45. And then I'm going to impose a mandatory cost of $210, a $100 fine, a $25 attorney's fee. I'm not gonna charge for the assessment fee. Did anybody request this assessment? Did the people or the defense request a pre-sentence investigation?
Not to my knowledge, Your Honor.
Defense did not, Your Honor.
I'm not gonna charge, I'm gonna just take, the court will take the hit on that. So the total fines, costs, and fees. Is $380. Additionally, you shall not use or possess any illegal substance. No marijuana without a medical marijuana card, no opiates without a prescription from the doctor. You're going to attend Gamblers Anonymous and Gamblers Counseling. Those are two different things, Ms. Townsend, okay? Those are two different things. You're gonna attend Gamblers Counseling at least once a month. That means I want at least 4 sessions of Gamblers Counseling. You're gonna attend Gamblers Anonymous. Well, she's off the disassociated persons list, so I'm only gonna also do once a month. But those are two different things. So you need to get a referral for Gamblers Anonymous, and if you need one for Gamblers Counseling. Because probation has to refer you to a Gamblers Anonymous that will sign your attendance sheet. Okay. Ms. Townsend, don't go to a place where they say it's anonymous and therefore I can't sign the sheet. Okay. It is court ordered and the people are having trouble and they get mad at me. So you have to prove that you went. And you can't take a picture of the screen, do not do that, because those people are anonymous. They're not court ordered to be there. Well, even if they aren't ordered by me. So you can't take a picture of the screen. Someone has to like give you some other proof. And probation can refer you to a proper place, okay? Okay. If you do those things, and come back to see me, there was a recommendation for mental health evaluation. I'm not ordering that. If you come back to see me, June 18th with those things completed, then I will discharge you and dismiss the case, okay? All right, thank you. You're welcome. Can we do her order now? Okay, oh, did I sign the other panel? No, still not. Okay, we'll see when they in the hall, I forget about it. So you might want to have a seat on the back row, okay, so I won't forget about it. Thank you, Judge. You're welcome. I'm gonna sign here so he can go. And the prosecutor is back, so counsel, I'm ready. I think Mr. You said, wait, did this person just come to court the other day? Okay, I'm sorry. I was reading something. Yeah, didn't this person just come to court? No, okay, I'm sorry. You sent me somebody from court. What's my courtroom number? Oh, this 339. Oh, maybe, did they somebody sent me something? Saying that this person is deceased. I thought that came from you, but from court, 339. Okay, I'm sorry. I was like, what are you saying, Mr. Bryant? But look this person up, there, I just sent it to you. Okay, okay. Ms. Flanagan, I don't see it. Where's the, did you send me the probation?
Oh, no, it's up there on your.
Oh, sure. So still, because I'm in person. I'm in person, sitting right next to you. That's the kind of day it's been. I am in person, sitting next to my clerk. There you go.
But you look great doing it, Your Honor.
Okay. Ooh. And Amari never went to the room, so I'm gonna go ahead and put Amari. And then Mr. Hayes and Ms. Privilege, you all are all set, I believe, unless you're trying to tell me that you have another case.
I don't believe we do, Your Honor. We just wanted to make sure we were all set. Thank you so much. Have a great rest of your day.
And if it's a mistake, we'll call you back.
Okay, you let us know if you need us.
All right. Oh, okay. All right.
I'll send it to order.
This is.
This man, Your Honor.
All right, this is recalling case number 234521301, the people versus Maria Mangum. Defendant is charged with assault or assault battery. Today is the day set for final pretrial conference. Oh, Mr. McCree left. Okay, appearances, please.
For the record, Your Honor, Christina Rivera on behalf of the people.
Good morning, Your Honor. Attorney Ryan Ramsey on behalf of Ms. Mangum, City Mangum, who is.
And your P number, first your P number.
Oh, sorry, P73195.
All right. Maria Mangum. All right. Whew. It was a challenge, but here we are. Today is the day set for final pretrial conference. Counsel, how do you want to proceed?
Your Honor, if we could set this for a jury trial, please.
Well, we'll continue with not guilty plea on behalf of Ms. Mangum, and I will set it for a jury trial. My next available jury trial date. So the complaining witness did appear today. And so it seems like he's ready to proceed. So let me tell you how I've been doing my jury trial, counsel, now that you give me your choice. So I'm stacking jury trials, up to 4.
That's fine.
Cases a day, and then I can put you on one. I can put you on a day where you won't be the first in priority, or which would be an earlier date, or I can give you the date of August the 26th, where you would be the first case in priority. That means, the other ones wouldn't.
If we could have one of the earlier dates, Your Honor, my client still wants to discuss whether or not she wants a bench trial or jury. We'll set up for a jury at this point. Make a decision where not priority.
All right, so then let's go with. Okay, can you confirm? Is April 30th too soon, or do you want a later date than that?
No, later date than that, Your Honor.
All right. All right, then I could give you May 28th, where you would be, the 4th or 5th in priority, and then I could also give you, June 11th, where you would be the 4th in priority.
I would prefer the June 11th if we could, Your Honor. Please.
Okay. All right. And I can give you a final pretrial conference. So the other cases on that day have a final pretrial conference just the week before, June 4th and June 5th. So I could give you a final pretrial conference on Oh, I see why. Well, okay, so I can give you a final pretrial conference June 5th, and then that way you can, well, you're probably not gonna go to trial that day. However, it's possible that the other 3 cases would settle and you would be up to
I've
pretrial.
been there before, Your Honor.
Yeah, so
might
I'll
as
give
well.
you June 5th, and that way you'll know for sure if you have to make a decision.
What time on June 5th, Your Honor?
That would be at 9:10. Is that good?
That's perfect. Your Honor.
Okay. Well, in fact, I should give you a later time. Let me give you 10:30.
10:30?
That way I'll know by that time what the other 3 cases are gonna do. Okay?
That'd be perfect. Thank you very much, Your Honor.
All right, then you're welcome. Have a great day.
Oh.
I'm sorry.
One,
Yes.
I didn't get there. One brief thing, Your Honor. I apologize, I have to send myself emails or I forget things.
Mhm.
So Ms. Mangum, currently has a no contact order with the alleged victim in this case, which is her neighbor. When her neighbor gets mail that's direct to Ms. Mangum, they're having a third party actually drop it off at her house. Ms. Mangum, whenever she receives mail that goes to that person, will just have it returned to the post office to be delivered. We would ask the same consideration that just have a postal officer drop it off instead of having some.
Well, tell the post officer to look at the name and stuff on this mail. I mean, but don't even worry. One time, so they deliver stuff to my house all the time. And when they do, unless it's my direct neighbor that I like, I don't take it to the people. I just return it to the center. Ms. Ritter, tell your witness to please stop doing that. If they get some on Ms. Mangum's mail, just return it to the post office. Yeah, no contact. Is this a business neighbor or a personal neighbor?
No, these are personal. This is her residence. Your Honor.
Okay. Now you do know that means if they, yeah, okay. Yeah, okay. I mean, tell your post, write a nice note for your postman, post officer, postal worker. And just tell them, please pay attention. But don't say it like that, but yeah, I have a friend and they keep, it's 2 addresses, 2 exact addresses in a complex, but one I think is east and one is west, and they keep on delivering the packages and stuff to the wrong place. They just gotta pay a little bit more attention. They trying to compete with Amazon. They can't. All right. Okay, anything further?
No, thank you.
Nothing
All
else.
right.
Thank you, Your Honor.
Then we're all set for jury trial June 11th, and then a final pretrial June, Okay.
Thank you very much, Your Honor.
Have a great day. Stay safe.
Thank you.
Ms. Mangum, I have a question for you. Do you live on the west side or the east side?
West.
Yeah. Remember the other day, Ms. Stevenson client said it took an hour to get here? Okay, I was just I was being petty.
That's because it took me a half hour to pick her up and get back, Judge.
No, I'm talking about this other client, not the one you had to pick up. I'm talking about.
Oh, no. He had to get dressed and stuff. So he was real fancy. So he had to get himself together first.
I appreciate everybody's patience today.
Thank you very much.
Welcome. And then Miss Urell just put me in such a great mood. I'm not even stressed or anything.
Can I come in and say hi to Miss Sherelle, Judge?
You pushing it. She don't want to say hi to you. No.
Right, that's true. You're right. Let me leave it alone. You're right.
Only Miss Barrett.
Right. You go, Miss Barrett.
Mr. Urell, like, love
I respect those. Not saying she that old, but I'm just saying.
Oh, you talking
Okay, Judge. I was texting the prosecutor.
Oh, Miss Ritter, look at your phone. I did. Oh, okay. She texting you back. She doing it. Okay, I'm ready on. Let's get some of the other people that's been here a minute. Who else is that on the front? Oh, she's a review. Did I send you anything on Taylor? Because I think I did have some.
Only what we had last time, when Miss Taylor was here. The court had Miss Taylor come in person today, Your Honor.
Oh, right. Well, she was, that was the other day. Yeah, we don't have it. Okay. All right. And I'll be ready in a minute on Taylor. Let's get some of the other people going. What about, all the 8:30 people? Wait, do I have any more waiting on a complaint? Okay. So we're ready on Clay, Wessing, and White.
Right. Mr. Clay was a little late, Judge, but Ms. White has been here waiting.
Oh, I can't believe you finally. Okay, so who?
Ms. White's been here, Mr. Major's been here, Ms. Thomas, Mr. Bolden. They all been here waiting patiently.
You're way down. You've been way down. You went way down. Let's go with. Are any of these pleased though?
They are not.
Okay. Okay. Okay, let's see who gets ready first, then that's what I'm gonna take first. Mr. Majors.
Hi.
And then Ms. Ms. White. So I'm gonna take Majors, White, and then Thomas. This is case number. 224561601 versus Kyrie Rashad Majors. Defendant is charged with 1 count of assault or assault battery. Today's set final pretrial appearance.
For the record, Your Honor, Christina Ritter, on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Kari Majors. Mr. Majors, sir, please say your full name.
Kari Rashad Majors.
Today's set final pretrial conference. How are we proceeding?
Your Honor, if the complainant's presence was not required today, Mr. Majors will continue his plea of not guilty and ask that this matter be set for waiver trial.
Judge, my notes indicated on November 1st, there was a pretrial deal and a complainant was appearing in the court said today, final pretrial conference. I don't have no required presence for the complainant.
Officer Grant. Ms. Ritter, Ms. Stevenson, so the complaining witness previously appeared in November. The court is going to continue a not guilty plea on behalf of Mr. Majors. Mr. Majors, with respect to the trial, your lawyer has indicated by her words that you want to waive your right to a jury trial and have the case heard by me. Is that what you want to do?
Yes.
And do you understand that if I accept the waiver, that you will not have a jury to hear your case, that I will be the only decision maker?
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter into, to get you to waive your right to a trial? Strike that, don't answer that. To get you to waive your right to a jury trial?
No, ma'am.
Any objection from the people?
No, Your Honor.
Having no objection from the people, finding that the waiver has been made freely, knowingly, and voluntarily, the court accepts the waiver. I am going to set a waiver trial for April 4th. At 11 o'clock. How many witnesses do we anticipate?
Judge, 1.
All right, anything further?
No, thank you, Your Honor.
Nothing on behalf of Mr. Majors. Thank you, Your Honor.
All right, then we're all set. Mr. Majors, have a great day. Stay safe, and we'll see you on April 4th.
Okay, thank you. You too.
You're welcome. Ready on white, this is case number 234501401. The people versus Stephanie Lynn White. Defendant is charged with 2 counts of assault or assault and battery, 1 count of malicious destruction of property. Today is the date set for pretrial conference appearances.
For the record, Your Honor, Christina Ritter on behalf of the people.
May it please the court, Abdullah Mugni here on behalf of Stephanie White, who appears today via Zoom. Stephanie, could you please say your full name for the record?
Stephanie Lynn White.
Today is the date set for pretrial conference. How are we proceeding?
Today, we're going to move for a dismissal based on the complaining witness's failure to appear.
Ms. Ritter?
Judge, I don't see the complaining witnesses, Tiffany Foster or Calvin Milton in the waiting room. However, it's scheduled as a first-time pretrial conference. I respectfully ask the court to adjourn the pretrial conference and give the complaining witnesses one more opportunity to appear.
The court is going to deny defense counsel's motion for a dismissal. I will grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witnesses of their obligation to appear before the court. I am setting a final pretrial, strike it. I am setting a pretrial conference for March the, how many do I have on March 6th? What about the 7th? What? That's an afternoon, so how many do I have an afternoon?
March 7th. Two trials review. 5, yeah.
What about March 8th? I hope the magistrates have already put stuff on there.
March 8th.
All of the dates you gave.
I don't know, March 8th. Yeah.
Court is going to set the matter for March 8th at 8:36. The complaining witnesses are required to appear. Failure of complainants to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witnesses could not appear or should not be required to appear. Bond will continue with no contact with complaining witnesses. Anything further?
No, thank you, Your Honor.
No, thanks, Your Honor.
All right. Ma'am, you're all set until March 8th. Have a great day. Stay safe.
You too.
All right. MFD, did you all go in and try to communicate with the telephone that's in breakout room number 2?
I did, Your Honor. And the telephone is supposed to be signing off, trying to come in on video. That is Mr. It's a review, Your Honor. Mr. McCrimmon.
All right, I'm ready on Thomas and I hope I'm gonna say this name almost right. Schwesing. All right, Thomas first. This is case number 116178601. The people versus Tiffany Renee Thomas. Defendant is charged with operating with a high BAC, operating while intoxicated, and driving my license suspended, revoked, or denied. Today's the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, and Judge Ms. Thomas has another case on the 906.
That's the case I called. That's under 906. I only see one. Oh. Okay, and she also has case number 214479201 with the same charges. All right.
May it please the court, Abdullah Mugni here on behalf of Tiffany Thomas, who appears today via Zoom. Tiffany, could you please say your full name for the record?
Oh, see my son?
Please say your name.
Tiffany Thomas.
Today's the day set for a final pretrial conference as to the 2011 case. Well, as to both cases. How we proceed?
Your Honor, today we're going to ask that this matter be set for a jury trial.
Both cases? Are the people ready to see at the 906 case? That's why it's at 906.
So Your Honor, the people did try to see if the necessary officers were available for the 2011 case. Unfortunately, they are not this time, so we will not be able to see the case number ending in 786.
All right, so as to the 2011 case, the court will dismiss the matter without prejudice, as the people are not able to proceed. With respect to the 2021 case, the court will continue a not guilty plea and set the matter for jury trial. I will set a jury trial for July 1st. With the final pretrial conference of June 12th. Make that June 14th. At 19, anything further?
No, thank you, Judge.
Oh, thanks, Judge.
All right, then we're all set until June 14th at 9:10. Ms. Thomas, have a great day. Stay safe.
Thank you. You too.
You're welcome. Thank you. Mr. Shard. Okay. I need it. Ooh. Are you, do you have a actual witness or other than probation for the complaints? She, the complaint is here? Yes. I'm ready on Schwest. This is case number 116405401, People versus Jason Schwessing, SCHWESING. Defendant is charged with assault or assault battery. Today is the date set for an arraignment on a bench warrant with a big file. Appearance, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
May it please the court, Abdullah Mugni here on behalf of Jason Schwessing, who appears today via Zoom. Jason, could you please unmute your microphone and say your full name for the record?
Jason Lee Swayzen.
Okay, we can't hear.
Jason Lee Swayzen.
I mean, he was this low in the breakout room?
No.
Jason Lee
All
Swayzen.
right, today they set for an arraignment on the bench warrant. I thought you all told me it was pre-sentencing, however, it is not. I'm looking at the register of action, and he was sentenced on January the 23rd, 2013. Additionally, it says something about this was added to a payment plan, but he was supposed to complete, certain terms and conditions. And he at that time was represented by the late great Cliff Woods. Kate is alive. Mr. Movie.
Yes, Your Honor. So this is a 2011 case, I believe. This is a case that's been well over 10 years since it should have been settled. He's, to my knowledge, he's almost done with his probation. He just completely lost.
No, he's not. He's not almost done. What do you think he did?
To my understanding, all that's left is a few fines that he has to pay off.
Oh, that's not. Mm-mm. Mm-mm.
But nonetheless,
he owes $960. According to the register, where's the handwritten? I thought I saw. Yeah, according to, he's been capious since 2000 and this is, hold on, this is, Mr. Flanagan, what does this mean? Hold on. Did he have, he must have had more than one. Okay, did he have one? There's no talking in court.
Sorry. Good morning.
Ma'am, I just said there's no talking in court. Ms. Flanagan, look at this, tell me what this means. Is that on one of the counts, or can you look that up for me? All right.
Yes, Your Honor. So,
He had 2 counts?
yes,
Okay.
count 1, found not guilty by jury, count 2, guilty by jury.
Okay, well, then that means he only has 1 left. That says,
Yeah.
so let me see it. So tell me. So for this particular count right here. You see what it says? It says. So this is, which count was this assault was on that?
So that's count 2, and he was found guilty on count 2.
Okay, but then, so that says he applied, which relates to.
Yeah, it's still, what date is that?
August 8th, 2013.
There's no entry on August 2013. It goes from June 26, 2013.
Okay.
All the way down to reappear on October 31st, 2020.
Okay, Mr. Mooney, go ahead. What were you saying?
yeah, so this is a case, it's been so long, and he's at the point where he just wants it to be over and done with. He had completely slipped his mind. It was, it's his mistake that this isn't completed yet, but in his mind, he thought it was over and done with. He understands now it's not, and he wants to take it head on. At this point, it's been so long, Your Honor. He should be on the path to having this finished so he can get this expunged off his record and move on with his life. And that's exactly where he's at. He just wants to pay this off, a little bit more time to do so. And once it's taken care of, he can then work on getting everything expunged off his record and go back to being the man he was before any of this ever took place. Your Honor, at this point, he showed up to court now. He's going to show up to any other probation reviews in the future. He takes this very seriously, and he wants to take the bull by the horns and move on from this.
That's nice. I'm gonna request, some type of update from probation. I have an entry, I have a handwritten entry, that says he should have been, the case should have been closed. I'm looking at a handwritten entry on the handwritten registers of action that we complete in the courtroom. August 8, 2013, it says dismiss, defendant complied with delayed sentence. However, he still has a balance that's showing up in the system. I'm not going to just make him pay if he complied with the delayed sentence. So I'm gonna see if probation still has any notes, that he, oh, hold on, wait a minute. Yeah, this is him. It was two defendants. And so unless they wrote that on the wrong one, then see if they wrote it on defendant, see if that was on defendant number 2.
That was for defendant 2, August 8, 2013. Judge Giles applied for the late sentence.
Oh, well, they might have wrote it on the wrong one. Well, or maybe they didn't write it, maybe they put the entry in on the wrong one. I don't know. He owes $900 and some. He can be prepared to pay it at this next court date that I'm gonna give, but I wanna get an update from probation to see if he did do anything on the probation. It was two defendants, and there's an entry on his that I don't know. So let me get a 30-day adjournment and let's try to sort it out before I take his money.
Sure.
He can come March 1st. How many do I have? He can come March 1st and we'll sort it out. Anything further? 10 o'clock a.m.
No, thanks, Your Honor. I'm all set.
All right, so if he's willing to pay, he could be prepared to pay some of it. He can't pay it this time. I need to make sure it's him that owes the money. All right, sir, you're all set until March 1st.
Just to clarify, Judge, March 1st, he doesn't need to pay anything before that point.
Not yet, but I wanna make sure it's him. It's two different things. Plus, he might have some other stuff to do, like, you know, I'm not a throw money at the kind of judge. If he didn't do the rest of his stuff, he's gonna have to do it. I need to see if probation have their file. If they don't, then I'll figure out what I'm gonna do, okay?
Wonderful.
All right.
Thank you, Judge.
You're all set, sir. Okay, I don't know what time it is, but does any of my staff need a break? It's 8 people in the waiting room. You're not my staff, well, what you doing now? And neither are you. You could have been breaking while we were doing this review. I said my staff, that includes 3 people. Any of my staff need a break? Okay. Mr. Oh, he's not even on the screen. Oh, there he is. All right, who else is? Miss Barrett, when you ready, turn on your camera.
Ready, Judge.
Okay, Mr. Shar, you ready?
Yes, ready, Your Honor. Thank you. Sorry to hold you up.
That's okay, Mr. Shar. I look like I held myself up by letting them put all these cases on my docket today. Who's coming in probation for Taylor?
Mr. Farmer said you got to hold someone.
Oh, you here for Taylor too? Oh, okay. Oh, I thought you were just here for more. Okay.
Mr. Bolden's just getting a date, Judge.
Ms. Deason, I didn't ask for no help. I didn't ask for any help on how to do my documents. I didn't. But thank you for that information. That was so
Welcome.
helpful.
You're welcome, Judge.
And I don't know, these other people, they were here and then they left because I could clearly see their name has changed. Like whoever the only was and then Omari, I tried to bring that, they might not be able to be heard today. Or they might have to come back at 1:30 with Smith and Wall. All right, I'm ready on Kellis. And I'm ready on Ms. Barrett, what are you gonna end up doing?
Judge, I spoke with the prosecutor and there is a plea to this matter.
Okay, so then let me do, is Mr. Kellis there?
I hope so.
Yes, ma'am. Yes, ma'am. I'm here.
All right, I'm gonna do Kellis and then I'm gonna do Uriel and then I'm gonna do Taylor. So Ms. Coulter, just hang tight with me. All right. And I'm gonna do Bolden and then Clay, and Ms. Rambis does not have representation. She has MFD.
Okay, thank you, Your Honor.
I need.
Judge, I said everything.
Oh, did you hear? Oh, my court reporter needed a break.
Do you want to do one more piece out of it?
No, I ain't care nothing about Mr. Ritter's eyes going to the side. These are union workers in here, ma'am. These union workers, and they're gonna get a break. So, hold on, Mr. Kellis. My union worker need a break. Well, let's do this. Mr. Kellis been waiting. I'll do Mr. Kellis, then we'll get a break. So, Ms. Barrett, your client is here. Did she need to fill out an advice of rights form or anything?
Judge, I went over her rights, but she can sign one if the court will pass it to her.
That's good. All right, let me do Kellis right quick. I'm not gonna rush you, Ms. Kellis. When I say it right quick, I didn't mean like I'm gonna rush you. Don't worry about that. And then we'll take a break so that I can refill my cup and my court report can take a brief break. This is case number. I appreciate everyone's patience today. I almost don't want to do Ms. Uriel yet because she put me in a good mood. She like, see, now she flashing back. She flashing back. All right, I'm gonna do Ms. Uriel before I lose the momentum. Okay, this is case number. 234480401, people versus Edward Michael Kellis, defendant is charged with weapons purchasing without a license. Today is the date set for sentencing appearances, please.
For the record, Your Honor, Christina Brenner on behalf of the people.
Good morning, Your Honor. Stephen Sharg on behalf of Mr. Kellis.
Your P number?
43732.
And Mr. Kellis, your name?
Again, good morning, Your Honor. My name is Edward Kellis.
Good morning. I have 1 minute left to capture that moment. Good morning. Today is the day set for sentencing. I've had an opportunity to review the pre-sentence report. With respect to the report, are there any additional deletions or corrections on behalf of the people?
Yes, Judge. So on page 1, Judge, under convicted by, just for clarity, there was a guilty plea to count 1 and 2 with count 3 dismissed.
Thank you.
I just didn't like how that was written.
I don't even know why it's on over. Okay.
And then, Judge, on page 4, under the police description, I'm not sure. Well, I'm kind of hesitant because I don't know where probation got that description from, maybe from the case itself, but that's not actually the description of this offense. This sounds like a whole.
Well, I was confused right there, but
Now, I will say that in this case, Your Honor, there is some back history that was in included in the police description.
But not
But
this,
not this.
right, that's what I thought.
So I just wanted to correct that for the court. And then, that were the only additional conditions of correction on behalf of the people here.
All right. Any on behalf of the defense?
Judge, I just want to let the court know that this case resulted of a raid of a location where Mr. Kellis was convicted and charged in Frank Murphy Circuit Court. He is on probation for those offenses, and respectfully ask you to file the recommendation of probation or run it concurrent with his probation in state court or waive the probation.
Hold on, I think you get to allocution, Mr. Sharp, just one moment.
Okay.
Ms. Ritter, any thing with respect to the people for sentencing?
With respect to sentencing, Judge, I do see that there was a 15-month recommendation from probation, and I asked the court to adopt that recommendation. Looking at the conditions by probation judge, there was a recommendation for anger management. I'm not gonna ask the court to impose that at this time, Judge. I don't think that has anything to do with the offense at hand, Your Honor. That was all as far as sentencing on behalf of the people.
All right, and anything on behalf of the defense, anything further?
Mr. Kellis, anything you want to say or?
No, not at this time. No, sir.
All right, I'm ready to oppose sentence, but I am gonna make this one observation. Probation said that Mr. Keller said, so that's double hearsay. Probation said that Mr. Keller said that they said he was uncooperative and he felt like he already did a pre-sentence investigation, so why are we asking him these questions? I mean, that's so silly. And one thing I know is that Mr. Sharp is a great attorney. I can't imagine that Mr. Kellis was confused about that he had a felony case and a misdemeanor case. I know he was confused. So that's because I told probation to ask the questions. And then here's the thing about running the sentences concurrently, which of course, they will run concurrently. But what I don't want any confusion about this. Circuit court don't run me. If I say do something different in circuit court, we're gonna do what Judge Bryant said do. I don't care about the judge in circuit court. I don't care about the probation in circuit court. I don't care about anything in circuit court unless I said it's gonna count in district court. So let's be clear, Mr. Kellis has 2 cases. He has 2 convictions. One is in the circuit court, one is in the district court. And the district court judge is crazy enough to believe she's the most important judge in the whole world. So I don't care about what the circuit court is saying. I just needed to make sure that was gonna be clear. I mean, I do care in a way, because I'm gonna look at the probation order from the circuit court, and if there's some duplicative things, then I won't make him do them twice. And so in that regard. So I was confused, as I said, by the description of the offense, because it didn't have anything to do with what was going on here. And okay, so we just all gotta do better. So I'm gonna accept that. How long is he on probation for, Mr. Sharp, in the circuit court?
I believe it was 2 or 3 years, Your Honor.
Okay.
2 years.
So that'll, and then, okay, so that goes. I'll accept the 15-month probationary period. And of course, he will be eligible for early discharge after 7.5. So let's do 15 month is 12, 30, 40, 15. That's April 30th of 2025. And then a halfway point is 1, 2, 3, 7, August 7.5 months. So that would be September the 19th. So September 19th is his halfway point. I'll set a review at 10 a.m. If you complete these terms and conditions, you will be eligible for discharge. You shall not violate any criminal law of any governmental unit. That means new cases. The old cases don't count against you any new cases. You can't get any new cases. You must notify probation of any change of your address, phone number, or employment status. You must report to probation on a monthly basis. That means you have to report to the 36th District Court probation and whatever they're telling you to do in circuit court probation. You will pay $210 mandatory costs. Is this a maximum fine other than $500? Is there some lower maximum fine on the weapons purchasing without license?
I can pull that up.
Pull it up, because the legislature had changed some of them. So see if I'm not gonna fine them $500, but I was trying to see if it was one of the lower ones. There's no restitution, supervision fees for 15 months is $525. That's at a rate of $35 a month. A $50 assessment fee. Is he testing at circuit court, drug testing?
I believe so, Your Honor.
So I am gonna order your analysis, but I will accept the results from circuit court. Your analysis once a month for 3 months, and if I'm satisfied, if there's no positive test for any prohibited substance, then he can stop after 3 months.
Great, thank you.
That's what I thought, $100 maximum fine. So the fine, I wasn't sure, but I didn't want to go over that. So the fine is $100. So the total fines, costs, and fees are $885. I'm not charging a urinalysis fee because we're going to just accept the results from circuit court. You shall not use or possess any illegal substances, no marijuana without a valid medical marijuana card, no opiates without a valid prescription. And oh, yes, and the handgun intervention program. No driving without a valid license. I'm gonna order the choices program. Any outstanding tickets, this said, oh, well, he said he does have a $130 balance. And I don't know if that's on this case or another case. And then any warrants he has to clear up. He must remain in compliance with circuit court probation. And I believe those are the terms that were requested in the pre-sentence investigation, as Ms. Ritter indicated. But we're not going to order I'm not going to order anger management. I don't know where that comes into play at. All right, we're going to mail a copy of this order to the Lynise address, and probation is going to contact you at the phone number that ends at 7459. Anything further?
No, thank you, Your Honor. Appreciate it.
And then, Mr. Kellis, I did want to acknowledge that you've been very appropriate for court, and I appreciate how you're dressed. I forgot to mention it earlier. Thank you very much.
Yes, ma'am. Thank you. No problem.
All right, you have a great day and stay safe.
You too, Judge. Thank you.
Thank you all. All right. Okay, and then actually, Mr. Jesse, you can go ahead and take your break. I'm gonna keep going with the recording. Okay. So Ms. Urell, because I don't want to lose Ms. Urell. Come on up, Ms. Urell. Oh, okay. All right, this is case number oh, I had already crossed it off. This is case number 224557001, Pete versus Sierra Renee Urell. Defendant is charged with the assault battery. This is a recall, and today is the day set final pretrial conference. Appearances again, please.
For the record, Your Honor, Christina Rivera on behalf of the people.
Good afternoon, Melita Baird on behalf of Sierra Urel. Judge, I had a chance to speak with the prosecutor in this matter, and there's a an offer for her to plead under Hyder, and she wants to waive her rights and plead guilty.
And she eligible behind it. That's wonderful. Ms. Sherrill, you want to plead guilty?
Yeah, I did hide it before.
You did? Okay, we don't want you to do Hyder ever.
I don't want to, but I got to.
I'm talking about after this. How old are you? Okay. Well, this is your last chance anyway. Okay. All right, Ms. Sherrill, I'm gonna share my screen. I'm gonna share the screen there. On the monitor where you currently see your attorney, it's gonna appear. A constitutional rights. My question to you is, your lawyer indicated that she went over your rights with you. Did you have an opportunity to review the constitutional rights with your lawyer? You don't remember reviewing them?
Which one?
Did you have a right to a trial? And if I accept
Oh,
this,
yeah.
she went over those with you? Oh, you have to say yes or no?
Yes, ma'am.
Okay. And when you went over those with her, did you understand your rights?
Yes.
You understand that this is a misdemeanor, therefore you do have a right to a trial, but if I accept this plea, you're giving up your right to a trial?
Yes, because they told me basically like a 50-50, he said, she said, so.
Yeah, you got a 50-50 chance of.
Yeah, I got kids and stuff, so I can't.
You don't have time for it, okay. Has anyone threatened, this is a guilty plea too though, right? Okay. And so you understand that if I accept the plea, you're giving up your right to a trial?
Yes.
Has anyone threatened you in any way or promised you anything that wasn't put on the record to get you to plead guilty?
No.
Are you currently on probation or parole? No. So the other case you were saying you did hide before, that's over?
Yeah.
Okay.
Yes.
And do you understand that if I accept this plea from you today, that you may be giving up your right to an automatic appeal if you were to change your mind about the plea? You would have to request permission to set aside the plea or request from the permission of the circuit court to appeal?
Yes.
All right, raise your right hand for me, Ms. Sherrill. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Ms. Baird, are you gonna order your client or the prosecutor?
Judge, can we have the prosecutor voir dire her based on the fact of getting the actual date from the record, please?
Okay, Ms. Ritter.
Okay. Ms. Sherrill, I want to take you back to October 21st, 2022. Were you near St. Mary's in the Deputy City of Detroit? Yes. And is that within the county of Wayne? Yes. And on that day, at that location, did you come into contact with the non-Aldebanes? Yes. And when you came into contact with that person, did you strike or hit that person? Yes. And did you do so without their permission? Yes. And at the time of the offense, were you 23?
Oh, that's all. I think, yes.
What was the date?
October 21st, 2022.
Yes.
Okay.
So that's a two-part session.
Ms. Baird, is the defense satisfied with that factual basis?
Satisfied, Judge.
All right, the court is satisfied. I will accept a guilty plea to one count of assault or assault and battery. All right, I am gonna come back for sentencing. How long ago was the other Hyder case? How long?
I got offered in 2020 or 2021.
Was that in 36 across the street? Okay, so we don't have. Well, they should have still, let's see, 2021, and this happened in 2022.
You need a probation order?
Yeah, let's get, maybe we can, if I can
My
get some.
son was born in 2021, so it was 2021, so I got off where I had.
Okay. I was trying to decide if I was gonna do a pre-sentence investigation. I don't think I need one. I think I know Ms. Sherrill almost better than I want to know her. But, if I could get a copy of that felony order, because it's suppressed, so, but you should be able to still get it. Yeah, Ms. Barrett wouldn't make it get it, but you can. So give me that order. Let's set the matter for sentencing. I do have to give the victim an opportunity to come in and make a statement if they want to. Let's put the sentencing in March. What's a good day for you, Miss? She talking about that's too long. Look at
Both my kids' birthday in March.
Oh, when their birthday?
March 16th and March 23rd.
You want to do, when you want to? You want to do before, so before March 16th. Look at us getting along. That's so wonderful. That is so wonderful. Okay, what if we do it March 8th? Okay, and you can come on. Okay.
Well, Judge, I have a trial on that day,
I'm
so.
sorry, I didn't even ask your lawyer. You see, I'm over here just getting caught up. Oh, you have a trial that day, Ms. Barrett?
Yes, Judge.
Okay, what about the following Monday or Tuesday, the 11th or 12th?
The 11th's fine, Judge, at 9 o'clock.
Okay. At what time did you say?
You said 9, correct?
Yes, ma'am. Okay, yes,
Okay.
9 o'clock, March 11th. And well, we're gonna put it on the docket at 8:59, but basically 9 o'clock. That'll just let me know I didn't order a pre-sentence investigation and I won't, be looking for one. Okay.
Now, Judge.
Yes.
Miss Uriel is coming to me and she's indicating to me that she does have other cases out there, which I am not assigned to. I don't know if the court wants to pull those and put them on the docket for March 11th, but she says they indicate to her that there's some warrants on her.
They might be traffic.
Yeah, they put Judge Taylor, when I called up here this morning, she told me I had 12 warrants out for my arrest for tickets. So I had brought it to her since we tried to get cleared up.
Yeah, that's not, we can have Judge Taylor put them on the thing. They're probably no bond. There are no bond warrants for the traffic. It should be no bond warrants, I think. Yeah, it's a no bond warrant, so she could just go downstairs and they'll give her a court date. Stop at the window.
Okay.
And so that's for Judge Taylor.
All right.
Okay. Anything further?
Just one
No.
thing. So
I'm sorry.
with the case that's under her, I just need to know like what type of case. There's a couple of them that I see that she got.
I was on her for driving and stuff.
Okay. That's all.
How old is your son?
4,
3. You don't get your life together now. Okay, Ms. Uriel. Okay, that's good. Okay. Anything further?
No, thank you.
No, Judge.
All right, we're all set. If you want to clear up those warrants, go stop at the window and get a court date for Judge Taylor. Okay. All right. Have a great day, Ms. Uriel.
Awesome.
Okay.
All right. Thank you. Have a good one, Judge. Bye-bye.
I think so. Yeah. This is when I called it earlier.
Yeah.
Mr. Bolden, turn on your camera. Case number 204530101. People versus Khalid Carey Bolden, the defendant is charged with assault for assault battery. Today is the day set for final pretrial conference appearances.
For the record, Your Honor, Christina Ritter on behalf of the people.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Khalid Bolden. Mr. Bolden, sir, please unmute and say your full name.
Khalid Bolden.
Today's the day set for final pretrial conference. How are we proceeding?
Thank you, Your Honor. Mr. Bolden will continue his plea of not guilty and he continues his jury demand, Your Honor. We do have jury trial. Let's see what it is.
March 19th, let's see where he falls. I don't have any more. Oh, that's right. And I had a file upstairs. Oh yeah, I didn't have him, and I said somebody put that on there without my permission. Tell me the date that we. Well, McCutcheon is a go, Bianca, so he can't go that day. And it's gonna be a jury trial. So
Yes, Your Honor.
I'll put Mr. Bolden, okay, I already have Mr. Okoro, I'll move to April 2nd. Let me see if I can. March 19th. Can you call Judge here and see if they have, okay, 16 to tell me, when is this docs? I'm trying to, when is this Harvey, when is that final pretrial conference? Because I need to move that to April 15th.
Final pretrial, March 22nd.
I'm gonna put Mr. Bolden on April 15th. And I'm gonna make him first priority.
That's fine for us, Judge. I do, reminding the court, the people, of the age of the or I guess the complaining witness. And I think that was one of the factors the court was taking into consideration, the school schedule or the break schedule.
Everybody is out March 19th, is there? You saying March 19th is some type of break?
No, I'm not saying that. I'm just saying I don't know that the April date is either.
Oh, and then if I didn't consider it for March, I can't consider it. They just gotta take off school that day.
Okay, April 15th. Great.
Yeah.
Thank you, Your Honor.
Let's do a final pretrial conference, March the 23rd. Strike it. Now, March 23rd, hold on. So, that's a weekend. And I'm not here. Let's do a final pretrial conference, April 1st. At 9:10. Anything further?
Nothing here.
Nothing on behalf of Mr. Bolden. Thank you, Your Honor.
Bolden, you're all set. Have a great day. Stay safe.
Okay, you too.
Thank you. Before I do that, and I will get my own stuff. Mr. Clay? Okay, so I need Taylor. And then I'm gonna take a short break, and then we're gonna do the hearing, the bond hearing. All right, I'm ready on Clay. This is Clay first, then Taylor, but I just want Taylor up. Miss Lurch, you can come on up. This is Clay, case number 234524201, the people versus Michael James Clay. Defendant is charged with malicious destruction of property. Today's date set for review. Write that. Today's date set for pretrial conference. Appearance, please.
For the record, Your Honor, please state over on behalf of the people.
Janice Stevenson appearing on behalf of Michael Clay. Mr. Clay, sir, please unmute and say your full name.
Michael James Clay.
Today is day 7 pretrial conference. How we proceeding?
On behalf of Mr. Clay, we move for dismissal for the complainant's failure to appear.
Judge, it's the first schedule of the pre-trial conference, especially at the court, so during the pre-trial conference, we're going to play with this one more opportunity.
Court is going to deny the defense counsel's motion for dismissal, grant people's request for an adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation to appear before the court. I'm going to set a pretrial conference. How many do I have on February?
Yeah, March 8th, I think.
March 8th at 8:36. Complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complainant could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
Nothing on behalf of Mr. Clay. Thank you, Your Honor.
All right, sir, you're all set. Have a great day and stay safe.
Thank you, Your Honor. I apologize for arriving to your courtroom late, Your Honor.
Thank you, sir. I appreciate it.
So that was March the 8th?
Yes, sir.
Okay, at 8:30.
8:36. Have a great day. Stay safe.
Okay, you too, Your Honor. Have a great day.
All right, I'm ready on Taylor. Taylor, and then I'm gonna switch to Moore. So Ms. Dixon, once those others get ready, depending on how long Moore takes, I might have to interject in between, but this is case number 206071701, the people versus Terrell Simone Taylor. Defendant is charged with attempt police officer assaulting, obstructing, resisting in this case, set for the adjourned review appearance, please.
John Lewis, on behalf of probation, standing in for Officer McCall.
For the record, Your Honor, Janice Stevenson appearing on behalf of Terrell Taylor. Ms. Taylor, ma'am, please tell the court your full name.
Ma'am, that was loud. You was all of that. You hurt our ears.
Apologize, Your Honor.
Ms. Taylor, state your name.
Terrell Simone Taylor.
Thank you. Okay, Ms. Taylor, I brought you in person. What we gonna do? You going back there? Or we doing probation? Because, no, you're not. You've been playing around with me. Let me see, where's the thing at? That's not even it. I brought all this stuff down here. You've been playing with me. The other day, didn't I just say, just come in person, didn't I? Like, I didn't even expend much energy, did I? I was like, just come in person. You know why? Because I was thinking, instead of I want to do the probation. Officer Krabs, go over there and open up that door. Do you know what's behind that door? No, I'm showing you. I don't know if you can, I'm showing you. I don't know what it's gonna look. I haven't looked back there in years. That's where we put the jailers. And then there's an elevator in there and it leads, let me see, I can't see what they can see. What can they see? They can't see nothing.
It's just two films.
Oh yeah, you can see that cell page. And then it's an elevator.
Right here.
Right there, then they take you downstairs, then they process, you all trying to go there? Well, then why you not doing the probation? Oh, I'm sorry, Ms. Deason, I'm just talking to your client. Ms. Deason, did you have something? Because that's why we're in person.
Nope, I think that Ms. Taylor gets it, Your Honor. What we were trying to explain to the court at her last hearing was that she had been struggling with homelessness and unemployment. She's brought both of those factors under control at this time. She heard this court tell her to come to get to court in person, and she did that. I think that Ms. Taylor is ready to put this matter behind her and do everything that the court is ordered to do. And I don't think the court's going to have any problems with Ms. Taylor at all, Your Honor.
Are you ready?
Yes, it's really affecting my life now.
Is it?
Yes, like my job situation is not good.
Yeah, and then you want me to tell you, you know, my mind works so crazy. My mind be working so crazy. I don't even know sometimes what goes in my mind. But you know what I'm sitting here looking at and saying? I'm like, I mean, her teeth so pretty. Like, what's that gonna do in jail? Like, now come on, and you know some stuff. Okay. And then I was like, I'm thinking the probation was only. Miss Lurch, do I even have time? Do I even have time? Because let me say, the 1 year expired October 23. Now, I don't know if there was some cases in between there. Yeah, it must have been, because then September, I reinstated it for 6 months, and now we had 6 months. You didn't even want to do the probation. You want to go back and sit back there for a minute, see what it feel like?
No, I do not. Trust me, I don't.
And then I think, I mean, you know, it's been some work with DOJ and things and such like that. So I don't think they're giving them dry sandwiches in jail. I think they do give.
It's not nice. Like
it's not nice. And don't it stink back?
Yeah, and it's like the cells. I don't ever get put in a bullpen. I get put in an isolated cell, and they forget about you. I'm not trying to get forgotten about.
I know. I wouldn't be one to get forgotten about either.
I'm only 24, so.
Was this higher? Did you lose higher?
I never did higher before.
Okay, we gotta address that later. Miss Ritter, she acting like she, trying to cover this. We'll address that later, because you only 24, and this is an old case, which means, how old were you in 20?
21.
I still be, consent. She loved when I need her consent. Oh my goodness. Okay, so we'll go back to that, because you messing it up for yourself. But okay, Ms. Nurse, what's your report?
Your Honor, I actually do not have a file, could find a file, but I'm just going off of just the Hall's notes. It looks like she's paid her fines and costs, but I don't see anything about the remaining conditions.
Yeah, this is the report Ms. McCall sent me on January 23rd, which is why I just was like, I'm done. That they didn't do, Ms. Taylor didn't do the choices nor the anger management. Hasn't been reported to Ms. McCall. Everybody liked Ms. McCall, so they be like, oh, she's such a motherly figure. Maybe you didn't want to. Sometimes she probably go left on some people too. I don't know.
No, she's a good person.
Yeah, I know. I'm a good person too, but they don't. You wouldn't know it if you look on YouTube. They get on my nerves on there. They be trying to act like I mean, I do put the hammer down. I never brought my gavel in here. Okay, so pretty much nothing has been done. So are you ready? Are you ready? If I give you what I think I still have 6 more months, I'll probably still have 6 more months. If I give you 6 more months, September.
Actually, there's a year left. If you're doing.
Oh, because, okay, good. Okay, look at you getting saved by grace. Okay. So I have a year left?
Yes, ma'am.
Okay, good. Okay, you ready to do it? You're gonna do it?
Yes.
Are you sure?
My first, I can admit, one of my mistakes was picking a job, a 12-hour shift during the day, knowing my anger management is also during the day for an hour and a half, and that has something to do with it, but I no longer work there. But I took a big pay cut to get a job where I can work midnight to do anger management during the day. I went from $20 an hour to $13.25. So
it's some place that you was working at Amazon?
Yeah, but it's backgrounds, like they say they accept certain things, and then they're like, oh yeah. So they kind of steer me the other way. So
yeah, that will, but it'll keep you back a little bit, but it don't knock you down completely. You still do it. Okay. Well, that was a good I mean, it was a hard choice to make, but, you know, probably work out for you. I'm gonna reinstate you for 6 more months. Let's see if we can get it done. So this is what month? This is end of January, this last day in January, so March, April, May, June, July, so that'll be July. Is that enough time? Cause it's 12 weeks of anger management. Yeah, that's enough.
Yes. And he did take care of a warrant, Your Honor, or she did, I'm sorry. And she is employed with Kelly Services,
Okay,
so.
so what about July the? Twenty-fifth, is that good? July 25th? Okay. I'm writing on your paper, one more chance. And then I'm also writing on the paper, Ms. Ritter, possible item.
If I'm clear,
I wrote, well, if you're not here, I'm gonna just go ahead and do it. But it don't say I can get the approval of contractual people, it say the prosecutor's office. So I'm just letting you know now, I'm not gonna be receiving any approvals from the contractors. All right, anything further?
I have a question about the anger management with Mr. Rice. He, I guess he be built up a lot.
Yeah.
And at first.
I'll allow it. You wanna ask me if you could go somewhere else?
Yeah, cause he keep thinking I'm a dude, so he keep signing me up for the wrong classes, the male one. I'm like, no, I need the female one.
Right.
And then he tried to reschedule me, and then it's filled up. So if you could find me somebody else, please.
Yes, we will. Yeah, you can send her to somebody. Yeah. Even after you told him, he still decided you up?
I think it's because we go so long without talking. and
Right, yeah.
Yeah, so.
Okay.
And my name.
Okay. You can move her from eBay to somewhere else, or Miss McCall. Yeah, Miss McCall. Okay. Okay, anything further? All right, then we're all set.
Thank you.
Oh, wait, did I give a date?
A date, but not a time, Your Honor.
What date did I give?
July 25th.
Well, that's, okay, do I need to do a 3-month date to make sure you on track?
I'll come here and I'll come.
Yeah, let's do a 3-month date. So the July 25th is the 6-month date, but let's do a 3-month date. April, let's do April the. And, I think I'm gonna do the afternoon. What's your work schedule?
I work at 7 at night to 3:30 in the morning.
So you prefer afternoon, 1:30?
Yeah, that's fine.
Okay. So April 25th at 1:30.
It's the day before her birthday.
Is it?
Yeah, I'm 25.
Well, happy birthday. Come see me before you. I don't remember that. I'm gonna say birthday.
Thank you.
All right. And you can be on Zoom. You can be on Zoom if you want to.
Okay.
That's at 1:30. Okay. Well, really, because I'm not gonna be in person at 1:30. I could almost guarantee you unless I'm still in that trial.
Okay.
All right. Okay. We're all set.
Thank you, Your Honor.
Are we ready to go in?
I am. I'm gonna take a short break and go get me some more coffee, and then I'm ready on the thing. Thank you all so much for your patience. I had a heavy document today. So, yes, I'm gonna take a 5-minute recess and then I'll be back and I'm ready for, more. I'm ready on more.
I'm just gonna go get Ms. Taylor some referrals.
Okay, yeah.
Thank you.
Okay. Is it just one witness? Well, it might be, I don't know.
Michael is,
Okay, so it might be 2. Okay, Ms. Coulter, again, thank you so much for your patience. I didn't realize how heavy my docket was today. I'll be right back. Oh, also, can you email? Mr. Oh, she was not. Okay. Oh, we have it. Can you give me her order? And then email Mr. About Mr. Schwartz.
Oh, yeah, perfect. Yes, ma'am.
Email, yeah. See if, needs to assign somebody, see if they can.
Okay.
All right, this is case number 214548501 versus Regina Octavia Moore, defendant is charged with assault or assault and battery, and today is the date set for probation violation hearing. Appearance, please.
Good afternoon, Your Honor. Christine Ritter on behalf of the people, number 83505.
Good afternoon, Your Honor and staff. Jennifer Colthurst, P522876. I appear on behalf of Ms. Regina Moore.
Regina Octavia Moore.
Your Honor, defense is ready to proceed. Move to sequester all witnesses.
Ms. Ritter.
No objection to the question.
All right, so with respect to that, let me ask a question with respect to that. I know you're gonna call the complainant with what they at this point, that's. So you said you may call Ms. Lurks. Is there any objection to Ms. Lurks remaining in the courtroom? Or do you want Ms. Lurks to leave out of the courtroom from the probation department? Ms. There's, so the people have one, lay witness and then possibly Ms. Lurks. Did you want Ms. Lurks to leave?
Yes, please.
Okay, Ms. Lurks, step in the hall for me. Well, that situation, I might just give her a big.
Okay, yeah, down.
It's still.
Yeah.
She don't be answering. Tell Ms. Stevenson. Ms. Stevenson, come in and talk to Mr. Flanagan for me.
All right, here I come.
With respect to the hearing, any opening statement of any kind?
Very briefly, Judge.
All right, ma'am, you may be seated.
So, Judge, with respect to the hearing, it is a probation violation hearing. The people have reviewed the evidence that will be presented to the court. And Judge, I think the court is a little familiar with the background of this case. It looks like the victim is Tammy Robinson and the defendant is Regina Moore, our neighbors. The probation violation hearing stems from constant contact between Ms. Moore and Ms. Robinson, but specifically Moore, Judge. The contact that was in question for today's purposes is there a video of Ms. Moore getting in her vehicle and backing her vehicle up on the grass of the complainant witness. So of course, we hear from the complainant witness about that incident. And the court may hear from the complainant witness regarding other incidents relating to no contact order. I just want to be clear for the court that these are two neighbors, Judge, and the feud and the back and forth is a constant thing between these two neighbors, Judge. The people are very familiar with this case and the complaining witness contacting the prosecutor's office about this case. So I'm just asking the court to do with what's within the bounds of the law. I know Ms. Moore is on probation right now, and people are not sure how much time Ms. Moore has left. The people are asking at the end of this violation hearing judge that the court sees the evidence to either extend Ms. Moore's probation and or even refer to Ms. Moore to mental health treatment court. I know that she does deal with some mental health issues, as it was stated in a pre-sentence investigation. And during sentencing, I think it was brought up as well. I think that's a major issue as far as what's going on between these two neighbors, because the contact is unnecessary. And we're not talking about fist fights, we're not talking about anything major, we're really talking about petty back and forth between these two neighbors. And people are just asking the court to step in and do what's within the bounds of the law to make no contact provision very clear between these two.
Anything on behalf of the defendant at this time, co-person, in terms of just an opening statement?
Yes, Your Honor. The evidence will show that while there is a video that seems to depict my client operating a motor vehicle in a way that some might describe as being careless, that video has no definitive date or time. And so there's an issue as to the date, the time of the operation of the vehicle that's depicted in the operation of the vehicle that's depicted in the video. Consequently, there will be no violation of Your Honor's orders due to the fact that it appears, based on the description or the way my client appeared, that it was something that predates the probation, the sentencing to probation. And so consequently, we're hopeful that Your Honor will find that my Ms. Moore is not in violation of Your Honor's orders, especially the no contact order.
Okay, thank you.
Check your email for something I just sent you on Bryant.
Yes. Okay, the people may call their first witness.
Thank you, Your Honor. At this time, the people like to call Ms. Tammy Robinson to the stand.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Please proceed.
You may proceed.
Thank you, Your Honor. Good afternoon, Ms. Robinson.
Good afternoon,
Ms. Robinson, can you state your full name for the court, please?
Tammy Robertson.
And Ms. Robinson?
Well, let me ask a question. Are you saying Robert or Robin?
Robinson.
Robinson.
Thank you.
Thank you. And Ms. Robinson, I want to take you back to an incident that you reported to the probation officer. Do you recall that day?
Yes, September the 29th, 2023.
Okay. And do you recall who you spoke with in probation on that day?
Miss Donna, she was the only one that I talked to.
Okay. And you said Ms. John, you remember her last name?
No,
Just for the record, I guess the court purposes is done, is what, the probation. Okay. And, do you recall what you told the probation officer, Ms. Robinson, on this day?
yes, I had said that Regina Moore and her daughter, they studied harassing me, damaging my property and everything. And she talked to me and we just kept in contact.
I didn't hear the last part.
We kept in contact, because we talked. She was the only one that I could contact. And then we talked.
Okay. Do you remember, giving Ms. Lurch anything?
Yes.
What do you
I had
remember?
a video of Regina Moore riding on my grass. And, I had woke up that morning and she was riding on the grass and she was doing something, so I called the police. That's what I did, calling the police.
Okay. And then what did you do after you called the police?
Waited till they came, I was in the house. But when they knocked on my door, I gave them the recorder of what she did.
Say that again, you gave them a what?
A recorder of what she did.
Okay. And at that time, did you show police officers this video that you submitted to this lawyer?
Yes.
Okay. And do you recall what day that video was actually taken?
September 29th.
So the same day that you called the police?
Yes.
And the same day that you contacted Ms. Lurch through probation?
No. That wasn't the same day. I had been contact her, but talked to her. Regina Moore and her daughter had constantly been harassing me, doing other things.
Okay.
And it was a video to show her.
Okay. And Judge, at this time, if you can share the screen. Okay, Ms. Robinson, can you see the monitor in the courtroom?
Yes, I can see the video.
Okay, and do you recognize a clip of the video on that monitor in the courtroom?
What clip? Which?
Do you recognize the screenshot still video in the courtroom?
I see the video, yes, that's the video.
She asked you, do you recognize it?
Recognize it, yes, that's the video I have plenty of videos.
Okay.
Okay, let's focus, okay. Do you recognize this particular video?
Yes.
Okay, Ms. Ritter.
Thank you, Judge. And what do you recognize this video to be of?
Regina Moore house and my house is the other part over there, my grass.
Okay.
And that's my grass right there on the side of my house is where Regina Moore is bending down.
Okay, hold on. I need you to wait for the question. Okay, Ms. Ritter, what was the question?
Sorry, so my question is, which side of the video is your house, the left or the right?
My side from the video would be to the left, where the grass at, where the grass. That is my side, that's my bedroom on that side.
Okay, so the left side is where your house
Yes,
is located.
where my bedroom.
And is this the same video that you submitted to probation officer John Lurch?
Yes, I offer her a lot of video, yes.
This is the same video?
Yeah.
Okay. And has this video, from your knowledge, been changed, altered, or deleted in any way since you sent it to Ms. Lurch?
No.
Okay.
Not as I know of, I don't know, ma'am. I still have the video.
My question, Ms. Robinson, is has this video been altered, deleted, or changed in any way that you know of? Yes or no?
I guess it's not showing what she's doing, so I don't know. That's what I'm saying. I don't know about the video.
She said, if you know, ma'am.
Okay, that's what I'm saying, Your Honor, that I don't know. They're not showing what
She
she's
doesn't
doing.
know.
Okay.
They're not showing what she's doing.
Judge, at this time, if you play people's proposed exhibit one.
You can, but I'm not gonna watch it right until it's ended because she said she doesn't know. Okay, play it. Now, just don't speak until the question is posed to you, okay?
Okay.
So you can play it.
So Ms. Robinson, I just want you to watch on the screen.
If you send me something better, because I'm not looking at it, so I'm also-
Ms. Robinson, I want you to watch on the screen.
I'm watching, there's
No,
something
no,
deleted.
ma'am, please, okay, listen. Just watch the video and then she's gonna ask you a question. So wait for her to ask the question, just watch the video.
Ma'am, she asked me, Your Honor, have something been deleted?
She did.
Yes, it has.
Let me say this to you. I want you to watch the video and then wait for her to ask you a question.
Okay, let's say another video. So Ms. Robinson, have you had a chance to watch the video in court?
No, this is the first time in here, but that is, I have the
Hold
video.
on, let's stop for a minute. You're not listening to the question. Ms. Ritter asked the question again.
Did you just have a chance to watch the video in court, Ms. Robinson?
I watched it.
Okay, and has the video been changed? or what?
Yes, it has. I have it with me now.
That's not what I'm saying, Ms. Robinson. I'm asking you, has this video been changed or altered?
Yes, I say yes, it has. They're not showing all the part. When she came out, she was even picking on my house. She pulled cords. Something been deleted. She was walking all.
That's, no, there's no question. Ms. Ritter, she said something's been deleted.
Yes.
Just go ahead, Mama.
You may, please.
Okay, Ms. Robinson.
Let me ask a question. Up until the point that the video ended on this particular screen, was anything deleted from the beginning of this video to the end of this particular video?
Yes.
So you're saying that somebody has altered and removed something from the video that you sent to Ms. Lurs?
Ma'am, I don't know what happened. It's not what I have. I have the video.
Ms. Ritter.
I don't have no further questions.
Let's go in the back. My question is, it was my report. What y'all do? Did I send something on this one? Oh, I think I'm confusing Ramblers with. No, I apologize. My question is regarding this Ram.
Yes, so Ms. Randis, Ms. Lurch does have. But Ms. Stevenson volunteered that information.
Oh, about. I didn't like to ask that.
And she has a copy of the appointment to apply.
Who?
Ms. Grant.
Okay, Ms. Ritter.
Judge, before I pass the word, I just have one last question.
Okay.
So Ms. Robinson, in the beginning of the video, you were trying to explain what you saw in the video. Would you like to explain the person bending down? You were trying to explain to the court what that was. Can you explain what that was?
The person that was bending down, that's what you asked me?
You were getting ready to say something about the person bending down in the video.
No, that was Regina Moore. That was Regina Moore. But the beginning, she came out, she started bending down and looking at her car and everything. And she was all on the rest and she was looking. And she just started, next thing I know, she just started pulling from my house, just pulling everything, cords that I have, like cable cords. She was pulling them. She started walking all over there by my house and everything. And then she got in, she was on the phone.
Objection, Your Honor. There was no depiction of my client on the video pulling cables, whatever cords. And so I asked to strike that.
No, ma'am.
I asked for that portion to be stricken.
I mean, I didn't see the video, but it sounds like that's what she's saying, is what you're saying from the video, that's all.
Okay, I have no question.
All right, any questions, Ms. Coulter?
Good afternoon, Ms. Robinson. Ms. Robinson, is this a video that's from a Ring doorbell?
No, it's from my camera. I have a Ring video, but no.
And isn't it true that your camera has a date and time of a particular video?
Yes, it does.
And isn't it true the portions of the video that you observed did not have a date and time on it, right?
No, I have the date and time. Because when I'm doing the video, I can show the date and time on it.
And were you the one to clip, delete, or alter the video?
No, I never clipped or delete. Why did I do that?
And are you stating that you shared the video with another person?
No. Well, I brought it up here and I let her do the video, see it. But we never clipped or nothing.
When you say her, who are you referring to?
Don, Mrs. Don.
Okay, the probation agent?
Yes.
And did you advise her to delete, alter the video?
No. Why?
You didn't ask her whether or not you needed to present that to the prosecution, did you?
No, I presented it to the police. The police gave me a report.
Did you see the police delete or alter the video?
No, they didn't even have it. I was hoping they said.
Nothing further. Thank you, Your Honor.
Ms. Ritter?
No further questions.
All right, I have a question, I have a couple of questions. Ms. Robinson, so when you said, in response to Ms. Coulter, you said that the video was not a Ring video, but it was another camera video, correct?
Yeah, I have cameras in my house.
How do you get the video from those cameras?
How do I get them?
Yes, ma'am. Like if the camera records.
If I'm not recording it with something else, I can get it off of my own. When I save it, I got a hard drive, everything.
Okay. And how did you get this particular video off of the
Off the camera.
So the video can't just come off the camera, so we'll explain that to you. It's not a Ring video. If it was a Ring video, then like a video would come to like your phone or your, you know, you
Right.
can get it from the Ring company. And so this isn't a Ring video. Where is the video stored?
And then you could download it.
No, I'm asking you, where is it stored?
All over my house. I have one in the front, one in the back, one on the side, on both sides.
I'm not asking you where the cameras are located. I'm saying the information that comes, the recording. So if the recording, it comes to your camera, like, okay, let me see if I can explain that. Okay, so like right now, if I want to see what's going on my front porch, I would go on my phone and I will pull up the video.
Right.
Okay, now, the cameras that you have that are not Ring video cameras, and if you want to know what's going on those cameras, how do you see the video?
Looking at my camera. I have the monitor.
You have a monitor.
Yeah.
Okay.
Camera.
And then,
And on my phone, I have it on.
so it's another app that's on your phone. Okay. And then when you sent that to Ms. Lurs, right, that, you said you brought that up here and you showed it to Ms. Lurs.
Yeah.
And then how did Ms. Lurs strike that? Did you ever give Ms. Lurs like an actual, copy of the video?
Yes.
Okay. And so when you gave it to Ms. Lurs, the copy of the video, how did you give it to her? Did you email it to her? Did you text it to her?
No, I gave it to her from my pad. From
Gave
my
it to
phone,
her
from my.
Right,
from my
okay,
phone.
but if I say I'm giving you a video from this phone, I can't just give it to you, so I would have to text it to you or email it to you, or how did you send it to Ms. Lurs?
I didn't send it, I brought it up here and she just recorded it
Okay,
from her phone.
so Ms. Lurs,
Recorded from her phone.
say for example, this is your iPad. Then Ms. Lurs say, put the iPad right here, and then Ms. Lurs took her phone and recorded what was on your iPad.
Mhm.
That's what you're saying?
Yeah. That's the only way she could get it.
Okay. The part of the video that Ms. Ritter showed you up on the screen, was that included in the video that Ms. Lurs recorded on her phone?
Was it included?
Yeah, well, the video that you showed Ms. Lurs, was what was on the screen up here a part of that video that you showed Ms. Lurs?
Yeah, it was part of it, the some,
Okay.
that was it, some of it on there, but
Okay,
it wasn't everything.
okay, all right, okay, well, one other thing, because Ms. Robinson, I gotta be clear about this. Okay, so you said it wasn't everything, but is something missing from let me ask it this way. Is something missing from the beginning, the middle, or the end of that video?
It's missing, cause when she come out to out of her house, to her car, that's when she goes over there and starts and looking all on her car or something, and she just got her phone or something, doing something. But people say, what was she doing? And I don't know, she got her phone. So then, next thing I know, she gets up and she says, come on my house, and just start pulling stuff and everything.
And that happened before what I see on this video?
That happened when she was around that way, down her car.
Okay, all right. Are there any questions based on my question?
A quick question, so Ms. Robinson, as you told the court, this is the video that you saw in court was a clip of what you said to the clerk, correct?
I didn't send it. I was up here, she recorded it.
That's the clip of what you showed, or what you brought up here.
That's part of it or something, yeah.
So it's
That's
part of the
video.
Okay.
Yeah, the video.
So the part that you saw in court, that part of the video that you saw in court, has that part been changed or to leave thinking that way.
What are you saying other than change? Some been deleted. That's what I'm saying. Some been deleted. It's not showing on whole video.
I don't have no further questions.
Ms. Robinson, you said you observed my client bend down towards your car, correct?
Towards her car, not my car.
Um,
Her driveway is next to mine.
yeah, did you by chance toss any nails out by her car tires?
Nails? Why would I do that?
Ma'am, the question is, did you?
No, I,
Did you see Ms. Moore pick up any nails while you were out there?
when the video, no, she didn't. And if I had, do nails, ma'am, why would she park so close on my grass then? Is that action for it or something? So that's a lie. I never threw no nails. No nails never been there.
Thank you.
So that's what she was.
Oh, ma'am, there's no question.
Thank you, Ms. Robinson.
Okay. Anything?
No,
All right, thank you, ma'am. You may step down and, she's free to stay in the courtroom if she wants to. All right, any other witness on behalf of you?
Judge, people like to call, probation officer Dolan.
Okay. While we're getting Ms. Lurks, I need Ms. Grant to start a camera. Oh, wait, you can't. Hold on. Let me change the settings. Okay, now you can start the camera, Ms. Grant. And
Hello.
start your camera, Ms. Grant.
Hello. Hello.
All right, with respect to Ms. Grant, this is case number 225762501, the people versus Delisha Grant. Defendant is charged with, false unemployment. Today is a day set for review. Appearance, please, Ms. Stevenson.
For the record, Your Honor, Janice Stevenson appearing on behalf of Delisha Grant, who I believe is charged with false welfare reporting, Your Honor.
Yeah. Okay, yeah.
Thank you, Judge. Ms. Grant, please say your full name.
No, Ms. Lurks.
Delisha Lee Grant.
Okay, I need Ms. Rambis. Okay, so Ms. Grant, hold on, I got the wrong thing. Oh, here it is. Ms. Grant was she didn't have a seat. Ms. Grant was placed on a non-reporting probation, but she didn't complete community service. Did she complete community service?
No, ma'am.
So
I'm sorry, Your Honor, she is not.
Okay, so we'll give her another day. How long does she need to complete it?
Ms. Grant, when would you be done with the community service?
Let me just interrupt, I'm sorry. I want to just continue her to the final review of July 31st.
Thank you, Your Honor.
Does she have a date in my system for that day?
Yes, Ron. No time assigned though.
July 31st at 10 o'clock.
Thank you, Your Honor.
All right, you're welcome. And I have to find my notes about whatever you said. About, I said I was gonna waive some money or something, but I'll find my notes. All right. Okay, Ms. Grant, you're all set. Have a great day. Stay safe.
Thank you, Your Honor.
Virginia Rambis, case number 204412701, the people versus Virginia Rambis, defendant is charged with assault battery. Today is the day set for review. Ms. Stevenson.
Janice Stevenson on behalf of Virginia Rambis. Ms. Rambis, ma'am, please say your full name.
Virginia Rambis.
Ms. Stevenson, for some reason, I don't know, I left Ms. Rambis paperwork because I thought we had did her yesterday, but apparently we didn't.
She finished the engagement. She still has to go to choices. She owes $460, which she can pay in 2 weeks. She asked the court to waive the choices program, Your Honor, because the anger management is done and she can pay the $460 within 2 weeks.
I'm not waiving choices. When is her next court date?
May 3rd, I believe, Your Honor.
All right, we're gonna, May 2nd, we're gonna continue her to May 2nd.
Okay, thank you, Your Honor.
All right, you're welcome. At 10 o'clock. All right, have a great day, stay safe.
Thank you, Your Honor.
All right, Ms. Lurs, raise your right hand for me. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. All right. Ms. Ritter.
Thank you, Judge. Good afternoon, Ms. Lurs.
Good afternoon.
Ms. Lurs, can you say your name for court?
Dawn Lurst,
And Ms. Lurs, what's your occupation?
probation officer.
Okay. And Ms. Lurs, how long have you been a probation officer?
Almost a year. It'll be a year, March 27th.
Okay, and is that at the 36th District Court?
Yes.
Okay. And Ms. Lurs, I want to take you back to around on or about September 29th of 2023. Do you recall speaking with Ms. Robinson, Ms. Tammy Robinson on that day, or
Can I look at my notes?
whatever refresh your recollection?
It should.
Okay. And when you're done, just look up.
Okay. I have down October 5th.
Okay, so on October 5th, what was the conversation between you and Ms. Tammy Robinson about?
Ms. Robinson had said that she was having problems with Ms. Moore and would contact and was being threatened.
Okay, and do you recall what dates she mentioned that those threats and contacts were happening?
The first call came in on October 5th, and the offense date was October 5th because there was a police report.
Okay, do you recall any other date besides October 5th?
And I do apologize, did Ms. Lurs already say the year? Okay, can we put a year, can we get a year?
Yeah, I'm sorry, Ms. Lurs, can you give the full date?
October 5th, 2023.
Okay, and do you recall any other dates?
I met with Ms. Robinson on October 17th, 2023.
Okay, and what happened when you met with Ms. Robinson on that day?
She had showed me some videos that she had brought in on her iPad.
Okay, and do you recall how many videos she showed?
There were quite a few.
Okay. Do you recall a particular video that stood out or came to mind?
There was one video that showed Ms. Moore backing out of her driveway and then pulling forward and then backing back over on Ms. Robinson's lawn.
Okay, so let's go to that video. So October 17th, 2023?
The day of the police report?
No, the day she came in and showed me the video.
October 13th.
October 13th, okay.
2023.
So October 13th, 2023, she showed me the video. And this specific video, where Ms. Moore is allegedly running over her grass, is that the video that happened, or strike that? Did you know what date that incident happened on that?
I did not know the date, no.
Okay. Did Ms. Robinson say anything else about that?
She just told me that, you know, it had happened frequently and was just wanting to show me all of the videos. And I explained to her that the police report, and she gave me the police report number, and that was it.
Okay, do you recall what that police report number was?
I do, I have it actually.
Okay.
The police report was dated September 29th, 2023. And the report number is 230929-0165.
And is that police report in association with the video that you're speaking of?
That I don't know. It does state in the police report about the officer seeing a video, but I don't know if that's the actual video or not, because there were a few.
Okay. And Judge Master, you may. So Ms. Lynch, I'm gonna turn your attention to the courtroom monitor. And can you see the monitor, Ms. Lynch?
I can.
Okay, is that, well, strike that, let me ask this one. Do you recognize what's on the court monitor?
I do.
Okay, what do you recognize that to be?
Well, I recognize the driveway from the other videos that I had seen. And the side of the house.
Okay, so do you recognize the still shot of what this video is?
as in, I mean, I just, it's familiar from seeing the other videos, but I don't know.
Okay,
I'm sorry.
it's okay. Just at this time, without the court viewing the video, and I play the video from Ms. Lake.
You may.
Thank you. So Ms. Lake, I just want you to pay attention to the screen.
And the record just should reflect that I'm not watching, so if it's admitted, I'll have to look.
Okay, good.
Okay?
Okay, the video has been. So Ms. Lake, did you get a chance to view that video that was played in court?
Yes, I did.
Okay, now do you recognize that video from being one of the videos that was shown by Ms. Bryant?
Yes, I do.
Okay, and in that particular video, do you recall there being any change, alterations, or deletions with that specific clip that was shown?
That is shorter than the one that I had seen, but other than that, no.
No, okay, Judge, at this time, the people like to admit people who live in one.
Any objection?
Yes, Your Honor, I object to the fact that this is not a complete video. It's been altered, it's been deleted by someone. And consequently, I ask that you deny the admission of the video in this proceeding.
Ms. Lurch, I'm gonna ask you a question.
Yes, sir.
In the video that you just saw, from the beginning of the video to the end of the video, has that been altered in any way?
No.
Okay. And then at the end of the video, you're saying, strike that, no, I don't want to put words in your mouth. You said that it was shorter than the video that you saw.
Yes, sir. There was more in the beginning.
There was more in the beginning of it.
Yes.
Now, let me ask you this. So the video that you just saw, strike that. Oh. Approach. In the front? Yeah. Come around. Ms. Letters.
Yes, ma'am.
The video that you said that there's more at the beginning of this video, do you still have that video?
I do.
Where is it? Do you have your phone with you? The council come back. I'm gonna have you, well, let me ask you this before I do that. The video that you just saw up on the screen and the video that you are telling me is on your phone. What's the thing that's missing from that video that's on the screen? You're saying there's something that's gonna be at the beginning of the video that you have on your phone that wasn't on that video, correct? Okay. One other question before I send you off. The video that's on your phone, how did you get access to it? Like, how did you get that video?
When Ms. Robinson came in and met with me, she had her iPad and we were trying to figure out how to get copies of the video for the court. I recorded it from my phone from her iPad.
So let me give you an example. Let's say this is Ms. Robinson's iPad. Did you take her iPad, put it on place, and then take your iPhone and record what was what was being shown on her iPad?
I did.
Okay. Council, I'm gonna have you all look at the video that is on Ms. Lur's phone. Because so let me say this, I agree with Ms. Coulter's that the video, and it's what Ms. Robinson was, I guess, trying to tell me, even though she said it was different. She said it was different. I don't know anything. Let me ask this question. Do you see anything that was taken out of the middle? Did you alter the video in any way?
No.
Okay. Did you see anything missing from the middle of this video that they showed me?
No.
Okay. So this is what I want you all to do. I want you to go, I'm gonna take a recess. Actually, why don't you all go, you all have a, Ms. Ritter, the office. Why don't you all go in that office? And you all look at the video that's on her phone. And then I'll decide. I mean, I don't know if IT can get it up on the screen or whatever, but let me ask one more question before I let you do that. So just so I'm clear, the portion of the video that you saw on this screen is also in the video that you have on your phone.
Yes.
But it's something missing from the beginning.
Yes, but it's just more walking around her car.
Well, you know, it might be perfect because she said it was some ropes or something. I don't know. You all go in Ms. Ritter's office and look at the video, please. All right, take the witness and go. I mean, I go into Ms. Ritter's office, but it's not her office. It belongs to the court. Go out there in that room. No, Ms. Lurs. No, just Ms. Lurs. You know, back in the day, I used to have to sign work through lunch. Do I got to sign there? But it's 140. So y'all, if I had to sign a work through lunch, I guess I got to sign it because once you go past 1:30, I think they're supposed to pay you there.
Oh.
Yeah, ask them go out.
Okay, I'll put on that.
Really going an hour early. Or they let you leave early or something, once I work past 1:30.
Oh, okay.
Yeah. Miss B, oh, she's not even here. She in the breakout with that phone.
Mr. McCrane.
Oh, he on the phone, why she change his name? Why she change his name? That's his phone. No, I'm not doing that. But the two other cases, that was for 1:30, those, are they in jail or they be sitting in something?
I sent minutes and I haven't heard anything back.
Oh, okay.
I sent a minute on January 17th for both.
Okay. Well, it's you.
Okay.
And then look, you see these statues up here, I'm not gonna write it. It's okay. I don't even know why I did that.
I'll print off our way.
I'm not gonna write it, yeah, do that. All right, do I have anything to sign? I'm not doing those. Baylor?
Good afternoon.
Good afternoon, they done wore me out.
I see you look on
Oh,
your face.
my goodness. Baylor, do you see what Officer Krabs is doing to me?
Is that what you doing?
Yes.
He's feeling the effects too. Look at him.
He's like, no, just because I'm hungry. Miss Stevenson,
Yes, Your Honor.
why did you change their name in there if they're not on video?
Who?
Mr. McCrimmon.
Oh, because he got on video and he got on his audio. The little neighbor down the hall helped him.
Oh. Well, what is he scheduled for? Because they're doing something right now, they watching us.
Okay, well, I'm asking to continue him until early April so he can keep working with Dr. Alexander. He has eight substance abuse counseling done and all the money is paid.
Where's my docket? I must put my docket. I'm not messing with you, Mr. Flanagan. Oh, and I gave you my papers. I just.
Okay.
Mr. Flanagan, what is all of this? I've been signing stuff.
Of the 26th.
No, Mr. Flanagan, we're gonna have a meeting. I see right now.
I didn't get anything back.
Mr. Flanagan, you gotta check your email. Okay, where's my docket? Okay, well, come on, he didn't come out of the breakout room, Ms. Stevenson.
Okay. You know what? Probably we should shut it down, okay, Judge?
Yeah, just shut it down.
Okay.
Where's he at on here? Oh. Did I get a report on him?
I did not see anything.
Oh, let me see. Let's see if I got a report on him. Ms. Stevenson, I haven't done this in a long time.
What's that, Judge?
Continuously working till this time.
I know this is it's like the good old days up in here today.
You gonna have to speed it up next time. Let's see. Look, you know I'm writing on you.
And you know I worked till 7 getting the docket together. So if I hadn't done that, we probably never would have got out of here. Like never.
Oh, goodness. Okay. Oh, let's see. Yeah, I do have a report on him.
Okay.
Job. Let's see.
You did try to get him into Veterans Court and heard my argument to not do that.
Oh, okay. Well, I'm sending you his update right now.
Okay.
See what I'm saying?
I have the 26th. Yeah.
Oh, I knew you were
25th, 23rd.
29. That's funny. You're not. I sent you some stuff on 29. Watch me pull it up. Oh no. Let's see. Sent. Ms. Stevenson, I'm looking at a different screen. Let me know when he's out of the breakout room.
He is out.
Okay. You said the 29th? Wait, what's today? 31st, so that was Monday. So let's see if I send you anything. No. Well, I sent you something. I gotta start back, make sure I put order. I sent you something. Oh, this was just one order, 2 orders. Okay, you might be right. All right. All right, Mr. McCrimmon, start the bit. Oh, you can't, hold on. All right, Mr. McCrimmon, start the video for me. Okay, this is case number 196085701, People versus James Arthur McCrimmon. Defendant is charged with malicious destruction of a building. Today is the day set for review, Ms. Stevenson.
Janice Stevenson appearing on behalf of James McCrimmon. Mr. McCrimmon, sir, please unmute and say your full name.
Unmute. Try to hit that prompt and I need you to be stationary. Unmute. Mr. McCrimmon, come on now, stop walking.
I said, can you hear me now?
Okay, yes, but can you stop walking?
Yes.
Okay, what's your name?
James Arthur McCrimmon.
All right, so he paid the fines and costs. He has to complete his outpatient treatment and anger management. When did you want to continue him to, Ms. Stevenson?
until early April when he will have completed his coursework with the report says Eve, but Mr. McCrimmon says Miss Bumpus gave him Dr. Alexander at K.
Yeah, okay. He was, oh. Hold on, 6 months, okay. No, that's, I'll give him the end of April, early May.
Thank you very much, Your Honor.
April 26th. 10 o'clock.
He's gonna be coming in person from now on. Zoom was a good try. Now he's gonna go back to coming in person.
Well, if he's gonna get this, well, no, he needs to come in person, because we can't. Okay. All right, then I'll see you on April 26th, Mr. McCrimmon.
Okay, Your Honor.
All right.
I'm Mr. McCrimmon. Thank you.
All right, Ms. Stevenson, you can hang tight on Zoom off camera. I don't know, Mr. Flanagan said both of those other two cases are they're in custody, so I don't know if they're gonna sign them in, so we'll see. If they don't, then we'll do something different. I'll just accept it.
Okay.
Yeah.
I'll be.
All right. Okay, now we're back on the record, and everyone had an opportunity to view the video that Ms. Lurch has on her phone. I need you to stop talking right now.
I'm sorry, Your Honor.
Okay. Everybody had an opportunity to view the video. My question is, this is my question. Does anybody disagree that the portion of the video that was shown in court that I haven't seen yet is an uninterrupted portion? I'm not saying it's the complete thing that's on this Thursday phone. I'm asking, is there any disagreement that that's an uninterrupted portion of the video? Do you?
No disagreement.
Okay, so what Ms. Lurch showed you, there's nothing missing in the middle of this video from what Ms. Lurch showed you. Like that would indicate somebody spliced it in the middle.
I am no expert.
But it looked the same. It's only by preponderance of evidence. Now put that phone down. I need you to stop. You have excellent counsel. Okay. Okay, so now so this is what I'm gonna do. As it relates to I'm still on the defense's objection to the admission of the video. So I don't know a way to show Ms. Lurch, well, let me say this. The only way that I believe that I can see the complete video on the screen would be for Ms. Lurch to log into Zoom on her phone, and then me give her the ability to share her screen. But I've never tried to do that from my phone on Zoom, so I don't know how that could work. But if that's what we can do, then I can see the complete video in court. So do you all want to try that? Otherwise, I mean, I agree if there's a portion of the video that's not there, that it should be shown to me. Whether it's relevant or not, it would be the rule of completeness.
And that is true, Judge. In all fairness, I think that the whole video should be played. And if Ms. Lurch is assistant, then I can go for share her screen with her phone.
What I'm saying is this too, so also let me be clear. Usually when I'm on Zoom on my phone, if I try to play another screen that involves my video, it won't let me. That's what it's like being on a telephone, but we could try it. And then if not, I suppose, it won't be the first time, I guess, that we've had to see okay.
We do a big court camera.
Yes, we don't have to, I mean, I guess, I just like stuff to be on the records. We tried IT, they the ones that couldn't get it off of there. I know, I shouldn't have said that. I'm sorry. Yeah, can you log in as on your phone? We'll try it, and then I guess if not, what I'll do is, it wouldn't even be an in-camera, it wouldn't even be called, considered in-camera. I would just have to have you all come up here while I watch the video to make sure that I'm not seeing anything that's other than what I'm supposed to be seeing, that's all.
Okay.
It's 153. That's what y'all know, I mean, I'm just saying, I didn't, it's nothing about it, I just making an upgrade. So tap up in that top thing to turn off your sound. Yeah. Yeah, come on. Oh, I gotta make her co-host in order to share the screen. Okay. Oh, look at Miss Ritter acting like she better at Zoom than me. I mean. Okay. Okay, so hold on. So before we play it, what I'm gonna do again is now I'm gonna turn away. Just play up to the part. Well, let me. Ms. Coulter, is there any objection to the full video that you saw on Ms. Lur's phone?
Yes, Your Honor, I guess it would help if I knew the name of the camera system to determine if whether the date would be in the original video feed versus the date someone recorded it from
The phone, I mean, I know, well, that kind of was a question for Ms. Robinson. Because I don't know that Ms. Lurch would be able to answer that question, but you can recall Ms. Robinson. So, you know, of course, this is a probation violation, just hearing just before the bench. So if I see something, I can unsee the part. Because I still need to make a determination if it's relevant or admissible anyway. So I'm actually gonna go ahead and admit the video, but you can recall Ms. Robinson and ask that question. Because at this, because I'm gonna tell you this, well, I mean, at this point, and based on Ms. Lurch's testimony at this particular time, Ms. Coulter makes a great point about the date, not the date that's up there on top of Ms. Lurch's phone, because I know when she received the video, but the date of the conduct that is the subject of the video is still sort of that issue, perhaps a little bit. Okay, so I'm gonna overrule your objection to the admission right now, but we can double back to the, because I know what issue you're talking. I know what issue you're trying to address.
And I'm not necessarily, Your Honor, referring to the date on probation agent versus phone, because
Right, we see that date. You're talking about the date of the actual video from the camera.
Yes, it's.
And it's another date right there, September 29th. I see these dates, but I understand your point. I understand what you're saying for. So your objection is noted, but I'm gonna admit the video. So you can play the video.
Thank you, Judge. At this time, people would like to say people would really want. It does not move at this time, the video has ended.
Okay.
May I approach the level?
Say that again.
May I approach the level, let's take it off the screen.
Oh, yes. Mhm. Okay.
So, Ms. Les, had an opportunity to view that video in court. Is that the same video that was submitted to you by Ms. Roberts?
Yes,
And is that in association with the, police report that you received from Ms. Roberts?
it has the same date on it, yes.
And what date was that again?
That was September 29th, 2023 at 12:49.
No further questions, sir.
Say what's wrong. It's real. I'm not saying I didn't say something. I got to look at my sheet first. Okay. To make sure that it's not just self-confident or so I'm not. Okay. Now this one says or. Well, I already said I wasn't gonna do it without my sheet, so let me just take them out. Okay. Okay. Ms. Coulter's cross-examination.
Thank you, Your Honor. Agent Hurst, are you able to tell this court with 100% certainty that what's depicted in the video occurred on the date of the police report? September 29th.
Based on the video, it said September 29th on the video, and the date of the report is September 29th. But the year is not on the video, so I believe it is, but it's not listed, so. No.
Okay. And you did not see Ms. Moore engage in any physical altercation with Ms. Robinson on the video, correct?
Correct.
You did not see Ms. Moore run over the complainant while she was backing up and moving forward out of the driveway, correct?
Judge, I don't object to relevant to the question.
You did not see Ms. Moore have any direct contact with the complainant, correct?
Correct.
Nothing further, Your Honor.
Redirect.
Commissioner Officer, conversation that you have with Robinson, did Ms. Robinson indicate that Ms. Moore, was having direct contact with her?
She did. She said that she had been threatened and that she was throwing rocks over the fence, but I didn't witness any of that or see videos, but she did say that she had had arguments with her.
Okay. Is Ms. Robinson indicating that she made police reports regarding this?
As she did, the police reports, she gave me the numbers of the police reports when she came in October. But the only one that I could use that was during the time of probation was the one that I received on September 29th. All others were before the date of the offense.
Okay, no further questions.
You said all other ones were before the date of the offense, that's the subject of the probation.
Correct.
All other ones except this one that I've just seen.
The police report for September 29th, that's the only one that I could use that was valid during probation.
So earlier you testified, because I was gonna ask you, so earlier you testified that she brought in several videos and, matter of fact, you said quite a few, that's what you said, quite a few videos. Of the quite a few videos that she showed you, in October of 2023, you're saying of those videos, that there was only this one that was alleged to have occurred after the probationary period?
This one, it was the only one I had a police report on.
Okay, so then let me ask you about the other ones. So even though you didn't have a police report on the other ones, was Ms. Robinson saying that those other ones occurred during the probationary period?
Yes.
What did you see on those?
There's one that Miss Robinson is videoing outside of her bedroom window, or out of the window. And then there's another one where they were arguing and the police were there.
The police were there while they were arguing after the probationary period?
Yes, sir. But there was not a police report to substantiate that. I didn't.
Okay, do you know what day that was?
I did not.
Okay. All right, are there any questions based on my question?
No, Your Honor.
And just to be clear, based on the video that was presented during this hearing, you did not see Ms. Moore throw any rocks at Ms. Robinson, correct?
Not at Miss Robinson, no.
And there was no indication that Ms. Moore threatened Ms. Robinson in the video, correct?
Not in that video, correct.
And can you tell this court with certainty, whatever other videos you referred to took place in 2023 versus 2022?
I would have to go back and look at them, so no, I couldn't.
I'm sorry, I didn't have one other question. The other videos that Ms. Robinson brought in that did not come from the police, but the one where the police, did you record with your phone too?
Yes.
Do you know what the, you might not know this off the top of your head, my question, do you know, from that video, would you be the date that Ms. Robinson, you said she was recording this with her phone?
I believe it was either her phone or her iPad.
Okay, and then, what made you think, let me ask you the question this way, what made you conclude that that occurred after the probationary period?
I wasn't certain, so that's why I didn't include it.
Okay. All right. Okay, thank you, Ms. Lynch, you may step down, thank you so much. Any other witnesses on behalf of the people?
No, Your Honor.
Ms. Lynch, I want you to stay in the courtroom though, because I'm gonna, miss you. Did the defense intend to put on any proof? Your Honor? Okay. Oh, I'm stapling.
I do think.
Do you? You don't scan them all?
I can. So I can.
Well, I won't staple this one.
Okay. It's easier to staple.
Um,
Your Honor,
yes.
Ms. Moore wishes to take the seat.
I didn't hear you. I'm sorry.
Ms. Moore wishes to testify. Is that correct, Ms. Moore?
Yes, Your Honor, please.
So this is what we're gonna do then. We have to take a break. But also, let me tell you, well, let me give you my thoughts for a minute. I'm gonna tell you something, and then you can decide if we're gonna just all together come again a second day. I am very much so interested in the date that Ms. Lurch has testified to where the police came, but you said there was no police report, because here's the thing, I don't think it's fair to penalize Ms. Robinson for the fact that the police didn't like officially write out a report if they came to the location. Additionally, if they came to that location, well, I don't know if it still exists today because that it would have occurred perhaps last year, but their body cams would have been on, and so it could have picked up some things. And so your client has absolute right to testify, she does. But I'm wondering if I should wait until, that's why I asked you, had you intended to put on any proof? Because I believe I want to leave the people's proofs open. Because I'm interested in that, I'm just interested in that date. Because Ms. Lurch said it was, she thought it was, during the probation. So, Ms. Lurch, do you have a date? Do you know?
I'm looking, Your Honor.
And that's gonna take a minute, and what I'm gonna say is this too. So, I don't know under what circumstance the police would go to a house but not do a police report if there's a dispute. So are we sure that there was no report? Like maybe there is a report and we just don't have it.
I reached out to both, because the date that we were talking, that you're referring to, was Dearborn Police, and I did do a FOIA.
Why is Dearborn in Detroit?
I have no idea.
Do they live on the border?
I believe she is.
Oh.
So it was Dearborn that came out, there was no.
Wow, okay, that's probably why. Yes.
My client has changed her mind. She doesn't wish to testify.
Okay. Okay, then,
And Judge, remember that she just looked at there's no date. After the date.
in terms of, okay, all right, let's go ahead here, closing argument with Tracy.
Thank you, Judge. So Judge, at this time, as the people indicated in their opening statement, that this is a probation violation. And I know that this court knows that the burden of proof is different from the standard proof is beyond a reasonable doubt, but it is a preponderance of the evidence. And the evidence that was displayed, to the court through the video and through the testimony of Ms. Robinson and Ms. Lurz, the people want the court to know that this violation took place on September 29th, 2023, which was after Ms. Moore was sentenced to probation, which was May 1st, 2023. And in that video, that the court saw that Ms. Moore walked up to Ms. Robinson's house and it looked like she was tampering with something on her house. She got into her car and then rode over her grass. Again, this is a no contact directly or indirectly with Ms. Robinson. And the people believe that her property extends to that indirect contact with her because Ms. Moore at this point is antagonizing Ms. Robinson and contacting her through tampering with her property, tampering with her grass, whatever was hooked up to her house. And that is actually a violation in the case. I'm gonna ask the court to find Ms. Moore guilty of a probation violation. And again, as the court should move within the bounds of the law, and that is to extend the probation or have Ms. Moore do some type of mental treatment with her mental issues regarding communication. And again, I'm asking the court to take into consideration that there is just a preponderance of the evidence in this matter. And I believe that the people has met that burden through the testimony of the probation officer, Ms. Lynise, through Ms. Robinson, and through the video that was shown to the court. Thank you.
Ms. Coleman.
Your defense is respectfully requesting that you find that there has been no violation of Breyer's orders. For the witness indicated that there was no knowledge as to the exact date of the video. While it had September 29th, there was no year that was indicated in the video. Moreover, there was no depiction of Ms. Moore throwing any rocks at Ms. Robinson, no depiction that she was fighting her, tried to run her over with the vehicle in question. It only depicted someone who appeared to have been trying to exit their driveway haphazardly, mind you. But that was an isolated incident. It's not something that was chronic or serial driving on the grass. There was no indication that the grass in question was damaged. There's no pictures of tire marks, tire tracks in the grass on the ground. And while I did observe my client bend down looking at her car and tires and then stand up and making some movements towards the wall of the house in question, I just could not see cables or cords that Ms. Robinson testified to. Perhaps if there had been a clear picture of some loose cords, loose telephone wires, loose electrical wires, or cable wires or cords, that might indicate something, but my client is one who has tried her very best to complied with your Honor's orders, paid all her fines and costs, she did attend anger management. She did report when ordered to do so. Always appeared in court when ordered to do so. And it would surprise me that she would wait, I guess, weeks or months before a potential discharge to engage in an act that she knows would be in violation of your Honor's orders. Because there is no definitive date, year that was depicted on the video we observed, I'm respectfully requesting that your Honor will find that the people have not shown by a preponderance of evidence that Ms. Moore is in violation of your Honor's no contact order, or we do not know whether that act occurred prior to being placed on probation. And for all of those reasons, I thank you, and my client wanted me to address that she never failed a drug test, and she always provided proof of her mental health treatment from Lincoln Behavioral Services. And so because of all of those reasons, I would like for your Honor to please find that people haven't shown by preponderance of evidence that Ms. Moore is in violation of your Honor's orders. And if anything, we're respectfully requesting your Honor to consider discharging Ms. Moore from probation and allow her to continue to get the treatment she realizes she needs from Lincoln Behavioral. And it's an ongoing, lifelong treatment she knows she's going to need, and it's something she's committed to. And that's what she would like to do, continue with the doctors she's developed a rapport with, and continue to benefit from treatment. Thank you so much.
Just again, the people just reiterated an argument that the verdict is just a congress of evidence and evidence that was displayed to the court and viewed by the courts depicts the testimony from Ms. Robinson testified that on September 29th of 2023, Ms. Moore was getting in her car, walking around her car, got on her property, started messing with some cables on her house, got into her car and moved to her grass. It is a violation of the no contact order indirectly from Ms. Robinson by having contact with her property and antagonizing Ms. Robinson. So then there's a question that evidence taken into consideration of testimony when deciding what the verdict will be, and people are asking for the return to the verdict probation violation.
There's a lot going on here, and nothing that's going to occur at 36th District Court is going to ever solve it. It's not going to solve it. This is a unfortunately very toxic neighbor relationship. And it's toxic for several reasons. And not all of them have to do with the defendant. But a lot of it does have to do. I said what I said, I meant what I said when I said it. And see, the thing about it is this. The violation of probation in and of itself is punishable by 93 days in jail. And when the defendant flexes at me, based on just that little minor thing that I just said, I mean, immediately 93 days just popped in my head. Like I went from literally, I literally went from maybe I'll have the specialty court come talk to her if I find her guilty of the violation, to literally 93 days, right immediately. Now, here's the thing about it. The thing about it is that mental illness is serious. And mental illness doesn't know how to properly react and behave. And the thing that I know is that Ms. Moore has some mental health issues. But I'm gonna get to those. But if she flexes at me again, we're gonna address the mental health issues on the mental health floor at the Wayne County Jail. So let me just be clear. Let she flex at me again, we're gonna address the mental health issues on the mental health floor at the Wayne County Jail. Okay. So, I don't know if I ever said it in this particular case or not, but of course, you know, I always often talk about how I feel about being neighborly and things and such. And when you have a person who is on like 30, 90, 100, 200, it takes another neighbor who's on 10, 8, 7 to balance it out. But when you have two people that's on 500, the whole situation is volatile. When you got neighbor A and neighbor B, and they both up here, it's just a lose-lose situation. And that's what we have here. That's what we have. Why do I say that that's what we have? Because I don't know who the original victim is of the situation. Like sometimes it's back and forth and that. So I don't know who the original victim is. But what I know is everybody in this situation want to be the victim. So we've received, you know, I mean, the natural course of a criminal case may probably mean that the case is going to be going on for a few years, right? That's the natural course. The person gets charged, the person has to be arraigned, the person has to, you know, they come in, they have an arraignment, they have a pre-trial, they have a final pre-trial, they have a, you know, they might have a trial, they might have, I mean, you have schedules, you have this, you have that. And then that's like the natural course of things. And while that's going on, it's hard to tell a neighbor not to have, you know, contact with another neighbor because every little thing that the other neighbor is gonna say is contact. Now, what I found interesting was something that occurred in this particular case. In my absence, the matter was scheduled, I guess, for this bond violation hearing, and Judge Baltimore chose not to handle it. He adjourned it and he scheduled it for some way date in the future last week. Now, I was off work back in November. But what I found interesting was probably that nobody complained when Judge Baltimore did that. He didn't get any type of complaint or nothing. Nobody said justice is being denied. When Judge Baltimore adjourned a probation violation hearing for 2 months, didn't nobody complain about him. And then when Judge Bryant adjourned it for a couple of weeks. She got accused of denying justice and allowing stuff to go forth and go on and such. Okay. I'm not gonna even say why I think it is. Just don't know why it is, but I do know that there's all types of implicit bias that occurs even in our own minds, right? So that again just stresses the point of when two people are both on 9,500. Okay. Now, I am one of the people who believe in neighbors getting along. So when we first came here for the probation violation hearing that Judge Baltimore set 2 whole months after it first came to his attention, I said, the officer in charge said, oh, they just backed up a little bit on the grass. And then I said, oh, well, that's not a violation. That's not blah, 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 blah. So I set this hearing. Well, I set a date to determine if we needed today's date. Because then once everybody saw the video, then Ms. Ritter was like, oh no, it's more than just backing up over the little grass. Because I said, if my neighbor backed up out of the driveway just on my grass a little bit, I wouldn't care. I wouldn't even care if I had a PPO against them. If they backed up on my grass a little bit, I wouldn't care. Why? Because I'm trying to show myself neighborly. Because I want to get along with my neighbors. Because my one set of neighbors that's on the other street, because it's time for you to listen. It ain't really time for you to write. It's time for you to listen. Because my other neighbors on the other street, they don't really show themselves that friendly, so I don't even say nothing to them. When they come outside, I used to wave at them and stuff. I don't even wave at them no more, because they didn't wave back. And I used to say, hi, good morning, good afternoon, and they wouldn't say nothing back there. So I started just coming in my yard and being myself. They don't have to speak to me. People don't have to ever speak to me in life. So then I just, I kind of looked at the temperature of the room and said, oh, it's cold over there, so I'm gonna just talk to all the other neighbors that surround me. I have 2 neighbors to either side of me. They are the nicest people that I've met in my 57-year journey in life. We look out for each other. I have a nice neighbor across the street. I have like we just show ourselves neighborly. If one of my 2 neighbors on both sides of me backed up out their driveway and made a U-turn on my grass, I'll be like, are you drunk? Why did you make a U-turn? Why did you not just back straight out your driveway? Why did you back all over my grass? I don't play about my grass. Ask my friend. One time my friend was in my backyard and she pulled up on my grass to let my daughter back out. I said, if you don't get off my grass, what? I don't play about my grass. She was like, it ain't gonna leave no mark. Get off my grass. Let me address the standard. Standard is by preponderance of evidence. So by preponderance of evidence, one thing I do know is that when I take a video, so I'm just using my common sense and everyday judgment. When I take a video, if you text me today and if I take a video today and I try to pull it up, then it's gonna say that I took a video January 31st. So when I pull up the video video tomorrow, strike that, it's gonna say today. Then when I pull up the video tomorrow, it's only gonna say yesterday. It's not gonna give me the date, it's gonna say yesterday. And then if I pull it up, like today is Wednesday, if I pull it up all the way through Tuesday of next week, it's only gonna give me the day of the week. It's gonna say Wednesday, Thursday, Friday, Saturday, Sunday, Monday, Tuesday. Once I pull up the video on Wednesday, it's gonna give me the date. So now it's gonna give me the date. But if I'm still in the same year, it's not gonna give me the year. It's gonna say January 31st. But if I pull up the video next year on January 31st, it's gonna say January 31st, 2024. So if I pull up the video January 31st in 2025, now it's gonna say January 31st, 2024. Why am I saying that? Because when she came and showed Ms. Lurch that video and it said September the 29th, it was still in the same year. And the only way it would have been possible for the video to be old is if she had taken the video before September the 29th of 2023. She would have had to take the video, before September 29, 2022, she would have had to take that video that a year before. So by preponderance of the evidence, I believe she took the video September 29, 2023, because it said September 29, it said September 29. Had it been in 2022, it would have then said September 2022. That's what it was. So by preponderance of the evidence, despite the fact that that video didn't come directly from the system, because I tried to ask as many questions as I could about the system that she took it. I believe it happened on September 29th. Now, I was interested in the day that the police came and didn't file a report, but Dearborn, they probably didn't want to cross jurisdictional hassle, but don't come over here then. Don't respond. Don't respond to the stuff that's going on in Detroit if you don't want to do the work. Okay, that's just my little nugget to Dearborn. So I don't have the benefit of that, but what I have the benefit of is the video that was presented to me that shows Miss Moore looking down at her car or something. And she seems to be looking at something. She walks around her car a few times. So somebody may have done something. There might have been some things next to her car, some nails, I don't know, maybe there were some things next to her car that she was trying to investigate. And then what was not presented, was that there was any, so let's say she goes outside, there's some nails next to her car. So if I go outside and there are some nails around my car that appear to have been placed there, like somebody, what I'm gonna first immediately do is go inside my house and I'm gonna go to my video, or I'm gonna pull up on my phone, I'm gonna go to my video, and I'm gonna say, did somebody put these nails by my thing? And then I'm gonna look and see if somebody put the nails there. And then if I know who the person is that's putting the nails there, then I'm gonna, well, okay, I might just address it. If I know the person who put the nails there. If I don't, then I'm probably just, I'll file a police report and say, somebody put these nails next to my car, they're trying to flatten my tires. What I'm not gonna do is start yanking at my neighbor's house. I was gonna say which neighbor it was. I wasn't gonna start accusing the neighbor that's unfriendly and saying, why you put these nails by my house? Especially if that neighbor, like for example, has a PPO or we on probation. And then what I'm not gonna do is if I think my neighbor next door did, I'm not gonna back up and come on the grant. Okay. Now, Ms. Coulter said in her remarks about there was no damage to the grass, and I didn't see any. And the grass, it looked pretty, And I didn't see any damage to the grass, but that's definitely not a requirement. So the requirement is that Ms. Moore is to have no contact directly or indirectly with Ms. Robinson. And that includes intimidating Ms. Robinson, that includes harassing Ms. Robinson, that includes talking to Ms. Robinson. Arguing with Ms. Robinson. I wish it was the Detroit police that had come out here that day, because I would have got some more definitive information about that day, right? So, I am convinced by a preponderance of evidence that Ms. Moore violated her probation when she backed her vehicle onto the yard of Ms. Robinson. And when she was doing whatever she was doing at the side of that house, grabbing it, I don't know what she was doing on the house. I don't know. But I find that violates her probation. And so now the question is, what am I going to do about that? Right? So what am I going to do about the fact that she violated her probation backing up over that yard? Now, again, I do acknowledge that was back in September. So if I take my own thought process, that was in September. We now find ourselves at the brink of February. And I am also taking note that Ms. Lurst said that there were several videos shown to her. However, she couldn't, from her standpoint, she couldn't determine, well, I think she said she determined that some of them occurred before the probation, and then at least one of them may have occurred after the probation. That was when the police called. Now, I said earlier that I was thinking in my mind, I was just potentially going to make a referral to the special court. Then your client flexed up at me, rolled her eyes, snapped her neck. And then I said, oh, she don't seem like she's gonna follow whatever I say. She don't seem like she's gonna follow what I say or what Judge Holmes says. Seemed to me like she think it's just some little walk in the park and slap on the wrist. And in general, probation is. That's in general. And in general, let people know that probation is the alternative to jail. And there's only one flip to that. Probation is the alternative to jail. Jail is the alternative to probation. Now, Ms. Moore says she's doing her therapy. She wants us to know she didn't flunk no drug test, and that kind of worked against her. You know why? You see what I'm saying? You see how your client keep doing? You see what I'm, okay. Okay, yeah, okay. That worked against her because that let me know she wasn't high. When she did it, she wasn't on drugs when she backed up over that grass. She wasn't high, she wasn't on drugs, she wasn't drunk. That let me know she backed up over there with whatever right now she got. Yes, Ms. Colthurst, because she on her way to jail, so you can stand up and say something. She on her way to jail because that's the second time she rolled her neck at me and rolled her eyes at me in her probation violation hearing, when I'm assuming you're gonna ask me not to put her in jail. She's showing me that that's what she deserves. So go ahead and talk, say whatever you want to say.
Your Honor, as always presented for almost a year now, Ms. Moore has been under the care of a psychiatrist. And so her, I would say, involuntary responses are due to the challenges she has with her mental health disorders. Someone who takes, seems like dozens of medications, prescribed medications, mind you.
She might be overtaking them. Because if she didn't fail no drug test, right? If she failed no drug test, and my order said no, illegal narcotics, but also no marijuana without a valid medical marijuana card, no opiates without a valid prescription, and, so this is my order, no opiates without a valid prescription, and a letter of explanation from the doctor as to why they are prescribing these opiates, because in that way, we know if they're being overprescribed, cross-prescribed, this is having an impact on this. That's why I say and. So if she in fact has those medications, and without a letter of explanation from the doctor, that violates my probation order too. But so go ahead.
Your Ms. Moore has done everything that Your Honor required as regards to her prescribed medications, the prescribed medications, and perhaps Officer Nurse can share some information about what she has received from my client. This is
the medicine not working, and she's sitting there grinning me, and let me tell you this also. You know, it's a new day in court when the man leaps from his seat all the way to the judge's seat. So it's a new day. So I'm already on alert. That's why I'm gonna stand up every time, because I'm already on alert. When I'm here. Now we have plexiglass, but I told my officer there's a little break in the plexiglass, so I'm on alert. Right? Your client has grinned me twice. She has flexed at me. She has rolled her neck at me. And if she is allegedly on the medication, it needs to be stabilized.
Yeah, she's on her way to Lincoln Behavioral now to let her continue to go in that direction. She did miss her appointment because we did not realize we would be here.
No, she should have adjourned that appointment anyway. You're not gonna have an appointment on the same day of your probation violation hearing. You would have adjourned that, right? Because you would say, I don't know how long I'm gonna be at the court. So I need to get a new date for my appointment. I'll either adjourn it or I'll try to see if they can get me in early. But Ms. Coulthurst, here's the thing. I'm aware that your client has mental health issues. But what I'm also know is that there are people with mental health issues that don't, and everybody's mental health issues they're different. They're on different levels, right?
Right.
And to me, I'm a proponent of mental health, getting help for our mental health issues. I believe people should have a mental health evaluation once a year. I believe that, right? But your client is going to think she's going to use her mental health problems to thumb her nose at the court. She has mental health issues. She doesn't seem to be having a problem that I'm aware of, functioning in the other areas of her functioning in the other areas of her life. So what I'm saying is she was doing okay. So I know she got mental health issues, but she's been doing fine, right? Today, until she disagreed with something I said. So you could try to blame it on mental health issues, but she was okay. She wasn't gripping me. I didn't feel unsafe or anything before I started saying that I was gonna violate her. So she was okay. She was communicating with you. She was, whatever. She was laughing earlier. She was doing all it until I said, I believe that video. So understand that having mental health issues are not going to stop me from sending you to jail if I think it's necessary, because they have a mental health floor at the jail. What I'm going to do, I think it might be too late to call the mental health treatment court. Yes, Ms. Lurs.
For the mental health court, it's a 24-month program, and she's already done almost 18 months.
No, mental health is only 14 months.
Is it?
Yes. But I put her on probation in June of last year, I thought, May of last year, so she's not even at 12 months, she still has 14 months.
Okay.
And mental health court is 20, it's not 24 months, it's 14 months.
My apologies.
That's okay, thank you though. They go,
No.
yeah, call them and see. I am gonna put her on a tether though. You may.
Your Honor, my client has been experiencing some financial challenges. She has expressed some concern about her ability to pay the fee for, I don't know.
Mental health treatment court is free. They have all kind of grants and programs. They have all kind of stuff. I shouldn't say it's free, but they have all kind of resources that we don't have. They were never gonna hold the person's ability to pay against them because it's mental health treatment court. So, can they come?
They're coming to the.
This is what I'm gonna do. They're gonna interview her. Now she has a lot of medication that may not be acceptable in the mental health treatment board, and that's gonna be a problem. But Judge Holmes has, non-narcotic alternatives to, a lot of the opioid medication.
My client just assured me that the medication she's been prescribed is non-narcotic.
Okay, well then she should be okay for, mental health treatment court.
For the record.
I heard her what she said. She said she wanna go to jail. She don't wanna go to mental health treatment court.
I want to go to jail.
So this will.
My client has a minor child that
need of intervention.
well, you know, her 16-year-old was expecting her mom, Sheila, to pick her up, but my client was able to get someone else to pick her up from school. I'm saying that to say that she's a mother, she's been trying, it's been challenging for her with the mental health.
What is her problem? She crazy.
And I, share with her, she should just ignore the neighbor. But it's difficult for her to just ignore the neighbor, especially when
It's not difficult to ignore the neighbor, but it might be difficult to ignore the neighbor if you have mental health challenges.
And that's what I am referring to.
Nobody said that, but what's gonna happen is you're gonna stop.
So she gets very emotional when her children, she has an older daughter too, moved away because of.
I can imagine why.
What's going on with the neighbor. And so now the 16-year-old is looking for, other relatives with whom she could stay because she no longer, wishes to have any contact or communication.
Well, here's the situation. And unfortunately, unlike drug treatment, mental health treatment in the state of Michigan and probably nationwide doesn't have many options for inpatient options. Ms. Moore needs intervention. Ms. Moore needs more than what she's getting. Ms. Moore needs some intervention. And here's what Ms. Moore doesn't know. So, and she says she wants to go to jail, and the law says that she is able to choose to go to jail. And what's gonna happen is she's gonna go to jail for the probation violation and for the case itself. So she's gonna get 93 days on the case itself, and then she's gonna get 30 days on the probation violation. That's gonna be consecutive. It's not gonna be concurrent, it's consecutive. She's gonna go to jail for 93 days and then 30 days. And she's saying,
I understand, and my client does understand.
okay.
She just feels as though she's been a prisoner in her home.
Okay, well, be a prisoner in the home. I don't know what to say about that, Mrs. Coulter. That's not my issue. I was trying to give her an option, an alternative. She said she don't want the alternative. So let's go to the other alternative. Thank you, Ms. Coulter. Thank you. Now, Ms. Coulter, you know, I don't like doing people in jail like that. So this